Lordship, may I be
Order for 2 matters and applications, please hand over without mention.
order for
Let the order for 2 and the application slips come, then we'll take up the other matters. Yes, the other mentionings.
May I permitted to mention one matter for inclusion, Your Lordship, first appeal.
Hearing we are not taking up, ma'am.
Your Lordship, I'll indicate the urgency, Your Lordship. The urgency is that the other side, Your Lordship, has already preferred an execution proceedings, Your Lordship, and order has been obtained, whereby there's a direction on us to evict the place by 8th of May. That
Did
is
you
the
have any
urgency.
stay application?
Yes, we have, Your Lordship, but it's the first time. It's coming for the first time.
Then we have to mention the stay application. Where are you mentioning the appeal
Yes.
hearing?
Yes.
That is what we are saying. Applications will take up. Mention the application, right? Application there.
Your Lordship, may I permitted to mention 2 matters, Your Lordship, of the non-prosecution.
Non-prosecution.
Any matter is amicably settled.
Yes, I will come back. Yes.
May I mention, my lord, one hearing for inclusion, my lord?
Very short matter, my lord. My lord, is an appeal because with the liberty to
Some of the other appeals are also short. We are not upgrading. I mean, we are sorry. Yes.
But 3 analogous matters where interim orders are expiring on 1st of May. But all 3 are assigned for your lordship.
Applications.
But these are applications, yes, can application and along with I'm enjoying interim order expiring on 1st of May
Yes.
for extension of interim order. Grateful.
I mentioned, my lord, one appeal hearing. I have mentioned this matter from January, my lord. I have, my lord, your lordship is directed in January. My lord, responding.
Immediately we can't.
Citizen, my lord.
We understand, but we can't. Yes.
In the month list of June, my lord.
No. No.
Otherwise, my lord.
Inclusion won't help because we are not being able to decide so many appeals. Yes. Yes.
Order gulo 17 দিয়ে দিন।
During the pendency of this appeal, the person at the disciplinary court, before whom it was held, he has recused himself. A new person has been appointed. Maybe this appeal will be infructuous. Lordship will
If it's infructuous, then we'll keep it as to be mentioned.
keep it as to, but I would require some liberty. But there are other points which are required to be kept open. Lordship, because
If it has to be heard, Mr. Ali, we can't take it right now. Sorry.
Lordship, may I permit to mention one first appeal matter, Your Lordship.
Hearing we're not taking
The
up.
defendant appellant were directed to file paper book by an order dated 7th March 2024 within 4 weeks. They have not filed yet, Your Lordship. That's why I'm mentioning.
Then
this
you,
matter.
it will come as to be mentioned, right? To be mentioned.
I have served the other
Yes,
side.
to
Your
be
Lordship.
mentioned. Yes.
Mentioning with regard to Kabaddi game, game is not
What are
suspended
you
due to
wanting? You're wanting inclusion of what?
wanting one interim order passed by the earlier court,
It's an application.
not hearing, but thereafter Supreme Court directed to hard on merit, without dispose of the
Has Supreme Court
hearing,
given a particular time limit?
not given time limit, but
No.
without hearing, entire play will be suspended, without.
No, you can file an application, we can take it up, but no.
May I have my lord's kind leave to mention, my lord is already hearing 2 appeals from a decree and judgment passed in preliminary.
Those are appearing in our list.
My lord, both have been directed to be returned on 30th of April.
What are you mentioning now?
My lord, I am filing a separate appeal from the same judgment and order, my lord.
Those
May it
can be
also
taken up
appear
together.
On 30th.
Indicate the item number and just put it on a slip. The item number of the other appeal.
My lord,
It's there.
I have not yet filed this appeal. These are
Once you file it, mention and say the item number of the other appeals, we'll include you. Because if the other appeals are pending,
they have returnable on 30th of April, day after tomorrow.
so you have to file this appeal and give us a number. Otherwise, how can we include you?
May I permit to mention, 2 matters for hearing, my lord.
Hearing we're not taking up. Yes.
to mention application for
Application, yes.
My lord.
Yes. Application, yes.
My lord, to be mentioned, my lord, earlier occasion, the department was directed to file a report. Otherwise, the matter is.
Has the report come? Have you checked
No,
up the
no.
file?
Till now.
Wait for the report. Whenever the report comes, pursue it with the department. Whenever the report is given, we'll just mention it. We'll keep it as to be mentioned.
To be mentioned.
Yes. Yes.
I have handed over the slip.
First matter. Call on. Accordingly, FMA number 711 of 2025 and FMAT 122 of 2025 are allowed on contest, thereby setting aside the impugned order bearing order number such and such and requesting the learned district judge, in the event of the absence of the district judge in charge, to dispose of the injunction application within 4 weeks from the date of communication of this order. As held earlier, the defendants in the suit shall file their written objection to the temporary injunction application in the court below within a fortnight. Consequently, can 1 also stands dismissed. No orders to cost, urgency.
Can 1 is disposed?
Yes, consequentially dismissed. Dismissed. It was your application.
Yes, yes. My lord is allowing the appeal.
We'll make it disposed of.
I'm sorry.
Disposed of.
I'm good.
Thank you. Allow dismiss for an application. Dispose of. Yes, Ms. Oja, what is the matter about? Why do you mention? Written notes, Acha. You have filed your written notes.
Yes.
Very well. Yes, on the last
violation that we have filed, we have referred those judgment in our written notes only. We did not annex it again. They have dealt with that.
The written notes of arguments filed by the appellant today be kept on record. Full stop. The matter is reserved for judgment.
Extremely grateful.
Thank you.
Item number 4, Lordship, I am pleading for the respondent by filing the written notes of argument. May I indicate one thing? The written statement of the defendant number 2 was not on record. I
You have given that
also.
also. The written notes of arguments filed by the plaintiff's respondents today be kept on record. Full stop. The matter is reserved for judgment. Meghnath, একটা জিনিস add করে দেবেন। The hearing is concluded and the matter is reserved for judgment. Thank you.
My lord, this matter, Mr. Shoyne Chakraborty is appearing on behalf of the appellant.
In view of the relatives of one of us appearing for one of the parties, comma, the matter is one of us bracket amar number. The matter is released on personal ground, full stop. Liberty to the parties to seek an assignment before a different bench.
Let's say when this matter is appearing at my instance, this is an appeal arising out of a matrimonial suit, which was held to be not maintainable. We preferred this appeal. An appeal was allowed by the other court judge. At that point of time, there was no direction for drawing up of the decree. And the department says unless there is a declared.
Learned counsel, you are for the appellant, Mr.
I'm for the appellant.
Learned counsel for the appellant points out that although the appeal had been decided by a judgment dated January 17, 2024, comma, there was no formal direction to draw up a decree. Accordingly, we direct a formal decree to be drawn up in terms of the judgment dated January 17, 2024.
I'm seeking for an accommodation.
We mentioned matter no accommodation. Why is it appearing to be mentioned?
Please make it not today.
কোনো idea আছে কেন? আচ্ছা। স্লিপে কিছু বলেছে? মেনশন স্লিপ নেই? প্লিজ বলেন ডাইরেকশন আসছে দেখি একবার ওটা দেখলে বুঝতে পারবেন। থ্যাঙ্কস। You are for the appellants? Have you filed paper books?
Yes, sir. As per direction of the last order, we prepared affidavit of services and paper publication.
Paper publication has been done.
And
we have to file paper books.
Paper books also.
Very good. Then we'll put it for hearing. The learned counsel for the appellants files affidavit of service which indicates that paper publication has been done in terms of our order dated April 7, 2025, full stop. Learned counsel also submits that the appellants have prepared and filed paper books
Yes.
Prepared and filed the requisite number of informal paper books. Accordingly, let the appeal be listed in the monthly list of May 2025 for hearing. It will appear for hearing in the monthly list. Monthly list means next week only. Yes. Photo appeal. Direction ছিল আমাদের। Why is it appearing as to be mentioned? Just remind us.
My lord, there is no application for stay.
Right.
My suit has been dismissed. So, my lord, it's an appeal, my lord, from the final decree dismissing my suit.
What is the nature of the suit? Declaration.
My lord, I will just summarize, my lord, in a minute. My lord, 11 lakh rupees paid in advance. Oral agreement for me to be sold a flat. I file a suit for refund of that 11 lakhs with interest. I am a company. The deponent signs the plaint who has the authority. The authority is general that he'll do the needful, sign affidavits, etc., etc. But it doesn't expressly authorize that he will depose as a witness. But that person, the deponent, depose as a witness. And the
direct knowledge that his deposition will be.
Yes, exactly. I have law, my lord, to my lord, contend that
anybody having direct
anybody
knowledge.
can have direct.
Your the group D stuff can.
The learned judge disregards my entire evidence on the basis that the authority to the person, the deponent, was not expressly to step into the witness box and depose. My lord, this is the matter.
But you have to give a notice to the other side.
Yes, my lord, notice has to be given, my lord. Records, my lord.
We'll give that necessary directions right now then.
And my lord,
yes.
and my lord, the defendant, after filing the written statement, did not even contest the suit.
Understood. But then we'll pass the necessary directions for putting in this the postal cost and all for.
My lord, just to save time, my lord, may I, my lord, file an informal paper book?
We'll direct that also so that you can come prepared with that.
Yes.
But the records have to come, I suppose.
LCR direction. Yes, my lord.
We'll pass those directions and direct you to file informal. How soon can you file that informal paper books? Have the papers.
Within a week, my lord, we can.
Oh, very good. You have all the papers.
We have all the papers.
Direction for LCR. LCR is regular.
LCR hai.
LCR has come.
No, my lord.
Could not have.
Yeah. Your lordship has to direct.
Learned counsel appearing for the appellant submits that the conspectus of the appeal is short, full stop. Learned counsel seeks directions for expeditious hearing of the appeal and submits that the appellant is equipped with the relevant papers and seeks to file informal paper books to expedite the hearing of the appeal. Which is the next para. Accordingly, we direct the appellant to put in postal costs and other requisites for service of notice of the appeal on the respondents within a week from date. Which is the next para. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. Which is the next para. We'll give you more time to file informal paper books because that will be the records have to come.
My advocate on record is keen to have this heard before the.
No, we understand,
vacation.
but unless they're served, we cannot do that, and the records come.
Understand.
The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 3 weeks from date. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Grateful.
I'm grateful. Paper book part we can take care of, but the other parts that you have to expedite. I mean, you know how. Yes.
Grateful.
Final item number 10, Mr. Shohini Chakraborty is appearing on behalf of the appellants.
But in view of the relatives of one of us within bracket Amannam appearing for one of the parties, the matter is released from our list on personal ground with liberty to the parties to seek an assignment before a different bench.
I'm grateful.
Item number 11, I appear for the
yes.
appellants, my lord. My lord,
for the
this
10 to
this
10, my lord,
has
opposition.
This is already having a checkered history.
Opposition to the condonation application or to what?
Yes, my lord. I am filing the reply to that. My lord, what has happened is, my lord, there were two issues which has come up before this honorable court at this present stage. One was substitution, which was allowed by your lordships. There were plethora of applications, and there was a second part, that is the suit. The appeal was dismissed for default way back my lord, and we needed to file a restoration application as well as Section 5 application.
So you have
My lord,
filed a restoration or a
Yes,
complete appeal?
yes, there was a restoration application already filed, but there were no Section 5 application, or I had to file the Section 5 application after having this brief. My lord,
The delay in filing the Section 5?
my lord,
I mean, delay in filing the restoration?
my lord, the restoration application suggests that it was the knowledge that the appellants had of the dismissal of the appeal after a very long period.
What is the long period?
Long period is 4.5 years. And why it was? Because, my lord, during that period, the appellant number 1 was not allegedly, I would not use the word allegedly because it has already been settled. It was murdered by the respondents, one of the two of the respondents,
They have been convicted.
they have been convicted and they are on life sentence. I have the
Have you
judgment.
stated anywhere that the appellant number 1 was looking
Yes.
after the matter?
Appellant number 1 was looking after the matter, but be that as it may, my lord, I have not stated this line, but it was the appellant number 1 who had, my lord, contended, and thereafter, my lord, in the year it was dismissed for default in the year 2006 due to non-compliance of certain formalities.
What sort of formalities?
Formalities, my lord, I will take your lordships to the orders. I am grateful to my learned friend that he has, my lord.
You have not annexed the order dismissing for default?
Yes, yes. It is there.
To the restoration application?
To the restoration application.
Where is
It is not the order, my lord. It is the information slip.
No, order is not there at all.
Order is there in my learned friend's opposition. They have appended. My lord, they were vigilant to this, my lord, and this order is at page 9.
You are given several times.
Yes.
Last chance was given.
Yes,
then
yes. Because appeal of 1991, second appeal. Thereafter, there was an order of my lord,
the order for 211 stage.
No. There was it was admitted. The rule was issued and it was confirmed. And thereafter, my lord, in the year 2006, the appeal got dismissed because of the two reasons, my lord. Kindly takes up page 10 of the opposition filed by my learned senior friend.
Yes.
9 is the order of dismissal. 9, I stand corrected. 9 is an order.
The order of dismissal.
Yes. My lord, page 10 of that opposition.
Yes.
Suggest, my lord, there were two issues which had cropped up before this honorable court. May I? My lord, we can very well ignore the office note regarding the fact that the application for substitution is not in time. In view of the specific office report that the legal heir of OP number 1, who have been sought to be substituted in place of OP number 1, are already on record as OP number 33 to 13, but we cannot ignore the last paragraph of the note. And before the application for substitution is finally disposed of, the defects noted there should be removed. Accordingly, the learned advocate is requested to serve the copy of the substitution application to the opponent and also to file an application regarding the attainment of majority in respect of OP number 11 to 13. My lord, 11 to 13 was minor when the appeal was.
So it was not there in the substitution. Did you permit you to file that application or anything of that sort?
No, my lord, on the next page, page 11, my lord, may I refer this? But it appears from the previous order there such and such that there was twofold directions upon the party. First of all, the learned advocate was required to serve the copy of the substitution application to the opponent, and secondly, he was also requested to file an application regarding the attainment of majority in respect of 11 to 13.
Yes, you have seen it, Mr.
Yes.
So office did not give any report. Did you do that at all?
My lord, what I find from the record, my lord, already the 11 to 13 is major, and my learned friend is appearing. And with regard to the substitution part, my lord, as of this day, my lord, everybody has died. All the respondent has died, and nobody is alive to, my lord. My lord, we have already taken out substitution application for the present being.
That has been allowed.
That has been allowed. Probably, my lord, in my humble understanding.
As on that date,
no, the
dismissal could not be faulted.
No,
but you had not filed that application.
Yes, the dismissal as on that date, my lord, although it was, my lord, these orders were passed by the bench and the Lozima court, my lord. But, my lord, I say, my lord, during this interregnum, my lord, during this period, there were issues of what I had primarily submitted. with
Order.
regard to the murder of the opposite, the appellant number 1, which is the issue here.
Have you annexed the conviction order anywhere?
No, my lord, I have not annexed. I have.
Where have you stated?
My lord, I have.
In your section 5?
My lord. My lord, I had at page 19, paragraph 7. I have got the copy of the order. May I?
Of the conviction order?
My lord.
Yes. Give a copy to your learned friend also.
Well, he has written in the opposition that he will definitely produce it before this honorable court. I have.
He says that an order of stay, no, he has admitted.
Yes,
he
yes,
says that
yes.
an order of stay has been passed.
Yes. But there is 2 issues that my learned senior friend has brought before this honorable court and also me, that I have explained the period from the dismiss for default till the application was filed, but instead of 4 years, I have written 3 years.
But the period has been explained.
Period has been explained. I have tried to explain in my humble way, my lord. But it was inadvertently, my mistake, my lord. It was 4, not 4, but 3. And there was also a mistake, which I admit, that in the scheduled property, I had mentioned it as a residential property. It ought to have been a agricultural property.
That will be decided in the appeal itself.
My lord.
Yes, what do you say?
My lord, this is the, my lord, the
Conviction is there.
no, my lord, conviction, my lord, nowhere, my lord, kindly, my lord,
The spectrum of death is cannot be denied.
No, my lord, this is, my lord, another issue, my lord, the entire, my lord, in this, my lord, issue, my lord, no, my lord, but another, my lord, village dispute, my lord, they are unfortunately, my lord, one of the, my lord, brother, name is involved.
True.
Don't get you. Yes.
Unfortunately, my lord, one of the brother involved.
Brothers of?
Father of the 13 to
brother of whom? Respondents.
Respondent
has not been
implicated, accused and then convicted. This is the, my lord.
No, we are not so much on the conviction. The fact of murder, that means he could not pursue the case.
No, my lord. This is the, my lord, no hair in my lord. Kindly, my lord, kindly, my lord.
Yes, it is not there in the restoration application.
No, in the section 5?
Yes, definitely.
Kindly, my lord, restoration application, my lord, kindly, my lord.
Let us come to the section 5. Section 5 explains the delay. If it is there, we will take that.
Paragraph 7. Page 19.
Yes, para 8 also.
Yes, my lord. One, my lord.
Yes, why shouldn't we allow this?
Ganapati Mondal and Pankaj Mondal, who are there in the appeal also.
They have been?
They were
convicted
along with all, there are brothers also.
Yes, we'll allow this application. The appellant who was looking after the matter was either murdered or whatever, he died. He could not pursue the matter. And in any event, the reason for the dismissal has gone now, because we have allowed the substitution and it's a technical thing now. We'll allow this application.
My lord, allow this application, my lord, another, my lord, kindly, my lord, express, my lord, appeal, because, my lord,
we will expedite.
My lord, this is the, my lord, otherwise, my lord,
the stage of the appeal, otherwise?
Well, it was admitted, paper books are yet to be filed. I have checked the record.
There was a direction?
No, there was no direction.
We will pass that direction, but it has to go before the single judge.
Yes, yes. And one more thing, my lord, your lordship on the last occasion of 16th of this month has passed an order which suggested that, my lord, there would be a stay on the execution proceeding of their suit, but it has gone down as this application to be a stay application. It would be a restoration application.
The Can 3 of 2024 is an application for condonation of delay in filing. Can 10 now it has been numbered as Can 2 of 10.
Yes,
in filing, Can 2 of 2010 within bracket old number Can 10611 of 2010 bracket closed, comma, which is a restoration application. Full stop. Then counsel for the appellant places reliance on the averments made in the application for condonation of delay and submits that the original appellant number 1, who was looking after the matter, was brutally murdered by some of the respondents. Full stop. 2 of the respondents have already been convicted on such count. Full stop. Thus, the family members of the said appellant, being the present petitioners, were in absolute disarray and had to stay away from their residence over the threat of their respective lives. And only after the accused, within bracket, since convicted, bracket closed, was sentenced, that the petitioners could have surfaced. Full stop. Next para. Learned counsel appearing for the respondents points out that there is no sufficient explanation for the delay in preferring the present restoration application. Full stop. That apart, it is submitted that the period of delay has been erroneously mentioned in the application under Section 5 of the Limitation Act. Full stop. Furthermore, it is submitted that the respondents, who were convicted, have subsequently obtained an order of stay from the appellate court. You have stated that also.
No, my lord, it is not there in the
Last sentence, second. So what is this stay about?
my lord, he is probably trying to say that
The
this
civil
order
matter.
was, see, this application, this appeal.
Last sentence, second.
This is my lord another proceeding, my lord, which are my lord.
Next para.
Same and subject matter of
Subject
dispute
matter,
or res judicata.
they have filed an
My lord,
application.
same
We find from the orders annexed to the affidavit in opposition that the reason for the dismissal of the appeal for default by the order dated June 15, 2006 was that the appellants had not carried out the 2 necessary directions as per the orders of the court. First, regarding service, there was initial inaction on the part of the appellants. Secondly, no application was filed indicating that the respondent numbers 11 to 13 had since attained majority. Next para. We further find from the submissions of learned counsel and the records that the said reason has now been rendered academic in view of the substitution application itself having been allowed after setting aside the abatement on the condonation of delay in making the same. That apart, the respondent numbers 11 to 13 are no longer there in the world of the living. 1 to 13.
No. 11 to 13 has already attained majority, and my learned senior friend is appearing.
Moreover, respondent numbers 11 to 13 have attained majority, which should be evident from the facts of the case. Next para, we find that there is substance in the reason for the delay in preferring the restoration application, inasmuch as the appellant number 1, who was looking after the appeal, had died during the relevant period. The 2 of the respondents have even been convicted for the murder of the said appellant. Next para, that apart, the mere mention of the period of delay in one of the paragraphs of the application is not crucial insofar as the entire extent of the delay has been sufficiently explained in the application. That apart, since the deceased respondents have already been substituted by their heirs and are already on record, we do not find any reason to attribute malefides on the appellants for preferring the restoration application late, particularly since due to the murder of the appellant number 1, there is every chance that the appellants were in hiding and not in a position to prefer the application. Accordingly, upon being satisfied that there were sufficient reasons for filing the restoration application late, we allow Can 3 of 2024, thereby condoning the delay in filing Can 2 of 2010. On the reasons as given above, Can 2 of 2010 within bracket old number Can 10611 of 2010 is also allowed on contest, thereby restoring the appeal to its original file and number. Next para, since the appeal was previously admitted, comma, the appellants are directed to file necessary uh, 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 the necessary number of informal paper books without comparing with the records within 4 weeks from date. Which the records are before this court.
No, record were had come up thereafter after the dismissal of this matter, the
Correct.
record has gone down.
The appellants shall also put in due special messenger costs for bringing the trial court records by special messenger. Full stop. Next para, such costs shall be deposited within a week from date as well. Full stop. Next para, you are appealing for all the respondents.
No, my lord.
Only
10 to 30.
The appellants shall put in postal costs and requisites for service of notice of appeal on the non-appearing respondents within a week from date. Full stop. Next para, the liberty to the parties to mention the second appeal for hearing before the appropriate learned single judge, then having determination as and when the appeal is otherwise made ready for hearing.
My lord,
My lord has restored this matter, my lord, appeal with all interim orders. It was there, my lord.
Was it?
my lord,
It was
one
there.
thing,
The
my
interim
lord,
order was there for, my lord, kindly takes up.
Was it vacated at that point?
No, my lord, subsequently, my lord, there was no such order.
There are judgments of the Supreme Court if there is no specific vacation.
No, my lord, there is no such
It
order.
is further noticed that in the order dismissing the appeal dated June 15, 2006, the interim orders then subsisting were not vacated, full stop. Accordingly, the interim orders granted at that juncture stand automatically revived as on this date.
my lord, respect to submission, my lord, service, my lord, other respondent my lord, I am appearing, my lord, 10 to 13. My lord, most of the my lord, other respondent, my lord, not served, my lord.
During the period of my
That's why you have directed postal costs to.
My lord,
and my lord, on the last occasion, your lordship was kind enough to direct the execution proceeding that my learned senior friend is proceeding with in their suit. In their suit was stayed until the further orders of this honorable.
You have revived the stay.
my lord, the appeal will be not delay, my lord, deal with the service, my lord. Again, my lord, service on that due to my lord service.
You have directed them to put in postal costs within a week. Next para, next matter.
My lord, again, my lord, refusal.
Who is appearing for the petition?
What is the Lord, I am appearing.
You have served on the other side.
Yes, Lord, I have served.
What is the affidavit of service, please?
Lord, most of the envelope is returned, my Lord.
Returned with what endorsement?
Lord. Yes,
There
my
is no good service has not been affected.
Lord. Yes, my Lord.
You have to serve again. All returned to sender.
Lord,
Addressee,
1K and OLA, my Lord.
addressee moved.
Yes, my Lord.
You have to find out the present address. The affidavit of service filed today be kept on record. Full stop. We find therefrom that most of the respondents who had intended to be served could not be served because the postal track reports indicate that the addresses have moved from their previous addresses. Full stop. The appellants are directed to ascertain the current addresses of the unserved respondents and to mention the matter before this court for leave to incorporate such current addresses in the cause title of the appeal, memorandum of appeal and the applications, and thereafter to seek directions for fresh service. Full stop. Let the matter go out of the list for the present with such liberty. Next.
I am for the wife petitioner appellant, my lord.
Appearing for the first time?
Yes, my lord. My lord, this is an application filed by the accountant general, my lord. My lord, what happened, my lord? Husband got decree before the trial court, the High Court of District. Against that order,
Divorce
wife-
degree.
my lord,
Divorce degree.
yes, divorce degree. And challenging that divorce degree, wife filed appeal pending. In the meantime, my lord, application number 24, my lord, alimony.
Use the microphone.
Alimony, my lord.
Alimony was filed.
Alimony was all disposed of by the Honorable Justice presided over by Tapan Kumar Datta. And in the year 2000,
You were the employer. Salary was attached.
no, my husband was employer before the Osanagar State General Hospital. He took VRS and my lord never appeared in these proceedings. Nowhere, my lord. At least my lord, 10 times he has served, refused. Advocate appeared, but not in the at the time of call, my lord. Honorable Justice Tapan Kumar Dotto passed 2,500 for alimony. Filed the application for recalling by the husband. Husband never appeared. That was dismissed by the Honorable Justice Somen Sen, presided over by the division bench. And thereafter, my lord, I filed application can 5, my lord.
What was dismissed? What was it?
Recalling application. Husband never appeared. Recall the.
Oh, the recall application was also dismissed.
Also dismissed by the Honorable Justice Somen Sen, presided. Thereafter, I filed to.
Means you are the wife.
I am for the wife. I filed application to deduct the salary. I know he has already retired. And now, my lord, I filed application for pension, my lord.
Pension attachment.
Attachment. My lord, Honorable Justice Modi Prasad, presided over by the division bench, passed an order to deduct the pension 2005 in the account of the wife. But my lord, pensioner officer, not 24/2, Treasury Officer 2, already directed that we have sent down all the papers and documents to the Accountant General. We have no record. Therefore, another order passed to the Accountant General to deduct 2,500 and in the account of the applicant from the salary, from the pension of the respondent husband. Now, Accountant General directed that he has no record. Already sent down to the Allahabad Bank, Jodhpur branch. And he.
Allahabad Bank holds the pension account.
Yes, my lord. Now, we also known as the Accountant General Office that branch manager Jodhpur Park, now it is Allahabad Bank, Punjab National Bank, merged with the Punjab National Bank. And husband withdrawing the pension from this branch. Accountant General my lord Sumon Basu, he filed application to modify this order. But I am also filed a supplementary affidavit. May I?
We are taking up can 5 and can 6.
Can
Can
5
5 is their application. That
my application, my lord, wife.
Achha.
In favor of wife.
Can 6 is.
Can 6, my lord, filed by the Accountant General for modification of that order to direct the branch manager Jodhpur Park, Allahabad branch, Allahabad Bank, Jodhpur Park, to deduct 2,500.
You also seek similar relief in your application?
Yes, my lord. No, at that time, my lord, I mentioned pension authority, my lord.
Then we'll dispose of your application because that has become redundant. We'll allow this application can 6 and we'll direct the concerned branch of the Punjab National Bank to deduct that amount.
Another thing, my lord, 3,60,000 area, my lord, since July 2014.
You could not serve on the husband?
Yes, man, I several occasions, my lord. I have filed affidavit of service. I also met with the advocate Anindo Bhattacharya, requested him to come at the time of call. He never come.
Give him a written notice. We'll keep it day after tomorrow. If he does not come, we'll decide this application.
My area also, my lord, 3,60,000 also area since today.
No, that we have to adjudicate. That is a fresh adjudication. That's why we want a notice to be given to the advocate for the respondent. Give a notice to him that the matter is appearing. We'll pass an order. We'll direct you to serve a notice on the advocate for the respondent.
I met and also I talked with what telephone.
Talk won't do. Give him a written notice.
I met and served I have also filed affidavit last occasion, 30th August, my lord.
The present 2 applications arise out of an appeal preferred by the appellant wife against a decree for divorce obtained by the respondent husband. Pushed up in connection with the appeal, a coordinate bench directed an amount of alimony to the tune of rupees 2,500 to be paid by the respondent husband to the appellant wife. Pushed up next para. Subsequently, the husband having defaulted in such payment, initially the employer of the husband was directed to deduct such amount from the salary of the husband and to transfer it to the account of the appellant wife. Pushed up. Subsequently, the respondent having retired from service, directions were passed on the Accountant General to disburse to undertake a similar exercise of deduction from the pension account of the husband and to transfer it to the account of the wife. Full stop. Subsequently, comma, it has come up before this court that the Accountant General's office has now sent the entire files pertaining to the pension of the respondent husband to the Allahabad Bank, comma, now merged with the Punjab National Bank, comma,
Jodhpur branch,
Jodhpur branch, comma, where the pension account of the husband is lying, full stop, next para. As such, comma, Can 6 of 2025 has been filed on behalf of the Accountant General seeking a modification to the order directing the said authority to deduct the amount and to direct the appropriate bank to undertake a similar exercise. Full stop, next para. Can 5 of 2022 is an application filed by the wife, which was for a direction on the Treasury officer to deduct the alimony pendentility and transfer it to the account of the appellant wife. Full stop. However, comma, in view of the changed circumstances as recorded above, comma, the said application has been rendered infructuous, comma, since the pension account of the husband is now lying with the Punjab National Bank, comma, Jodhpur branch. Full stop. Accordingly, we dispose of Can 5 of 2022 as infructuous, full stop, insofar as Can 6 of 2025, comma, since the appellant wife alleges that in the meantime, comma, huge arrears of alimony have also accrued for due to non-deduction of the alimony amount from the pension account of the husband, comma, we are of the opinion that the husband ought to be given another opportunity to be heard, full stop. Accordingly, the learned advocate on record for the appellant shall serve a written notice on his counterpart appearing for the respondent husband, indicating that the application that is Can 6 of 2025 shall be listed for hearing under the same heading on April 30, 2025. Full stop. On the returnable date, comma, the learned advocate for the husband shall learned advocate for the appellant wife shall file a receipt of such notice to that effect. Full stop. In the event the respondent chooses to remain unrepresented despite notice on the returnable date, comma, we shall take up the application for ex parte hearing and dispose of the same, passing appropriate orders. Please just serve a notice on the advocate for the respondent.
Yes, ma'am.
If you can, our order will be uploaded during the course of this evening. Serve a copy of the server copy.
Also, ma'am. Yes.
So it will be easier for you to
Yes, yes.
ensure that they.
I shall sub both advocate and also respondent.
If you do that, that's good. But then you will have to.
Again, man, I shall with
Advocate will
with
do.
server
Advocate
copy.
will do.
Yes, get me.
I pay for the applicant in this matter. I'm led by Shayantan Bose in this matter.
What is the application for?
Lordship, it was the order of stay was passed in this matter. Lordship, it was recalled as the respondent had been substituted, but we had served upon the
Yes, yes.
uh,
Now
respon-
the stay application is before us.
Yes, Your Lordship.
So what is your prayer?
Lordship, I'm praying for a not today because I'm led by Shayantan Bose in this matter.
Very well. An adjournment is sought on behalf of the appellant. Full stop. None represents the respondents as well. Full stop. Accordingly, let the matter stand adjourned for the day. Not today. Sorry.
Thank you. Now, the pursuant to Lordship's direction, Lord, I have filed, Lord, by amending the memo of appeal, by incorporating the left of defendants, left defendant in the suit as a pro forma respondent.
You did not claim any relief in the suit. No relief was claimed against the pro forma respondent.
No.
The appeal arises out of what?
The order passed by the learned magistrate, 23rd of July, 2017.
Not magistrate, civil judge,
2013.
senior division.
Yes, senior division.
You do more criminal matters. What is the decree for?
The decree for suit for partition and permanent injunction.
Preliminary decree you are challenging?
Yes, preliminary.
This is a section 5. What is the delay?
More than almost 4 years, because.
What is it? You have to serve the added respondent also, or no, it's a partition suit. You have to serve.
Partition
all.
suit.
You have to serve all. So the added respondent was. We don't find the section 5 application being corrected. The added respondent has not been added here.
Yes, section 5 also should be corrected.
You have to correct that.
All right.
And did you direct service of copy of the section 5? No.
No, 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 no.
Well, we'll direct you to serve copies of can 1 as well as 2.
And 1 as well as 2.
And we'll give you in the memorandum you have effected the correction.
Yes.
Let us just check up.
All the left out defendants, my lord, have been incorporated as a pro forma respondent.
Acha, we have filed a separate sheet for that. Very well. Leave is granted to the learned advocate for the appellant to add the left out parties, comma, in line with the leave granted on April 8, 2025 for correction of the cause title of the memorandum, comma, by implementing the said parties to the applications bearing can 1 of 2025 and can 2 of 2025 as well. Pushed up. If necessary, comma, separate sheets containing their names shall be added to the applications incorporating such names of the left out parties. Pushed up. Such correction shall be carried out. You can do that by tomorrow.
By
the end of this week, do that?
Yes, yes.
Shall be carried out by May 2, 2025. Pushed up. Upon such correction being effected, comma, the appellant shall serve copies of can 1 of 2025 and can 2 of 2025 on all the respondents, comma, including the newly added respondents, indicating that the applications shall be listed for hearing together on May 19, 2025. Pushed up. On the returnable date, comma, an affidavit of service to that effect shall be filed by the appellant. Carry out the corrections, please.
Yes, yes.
উনি ওই অ্যাডেড পার্টিদের নামগুলো দিয়ে দেবেন এই সপ্তাহের মধ্যে। You can copy paste from the additional sheet you filed with the memo of appeal. You can just copy paste there.
Yes.
Lordship's direction was to affirm a supplementary affidavit disclosing the delay filing the substitution application.
Copy as
Yes, so I prepared the same. My client could not come, but so far the affidavit of service is concerned. Lordship, 2 of the respondent Lordship service returned, Lordship, as the address is not found. Again, we have served, but Lordship track report is not available.
No, wait for that. In any event, you have to serve a copy on him. So track report is not with you means?
No, but track report is at present not available. It is showing not served. Delivered.
This arises from partition suit.
Partition.
Mr. Ghosh, you represented only 14 to 17 in the court bill also.
Yes, my lord. 9A to 9.
Only they have contested.
Only 5% contested with the learned trial court. I'm out of 5, my lord. I appear for 4.
For 4. What about the other one? He has been served. Which is the other respondent who contested, Mr. Ghosh?
He's the respondent number 22 here.
22 has been served. Mr. Mukherjee, please check up.
Yes, 20.
Abdul Sukur.
Take your time, check up whether he has been served. Others we can dispense with probably on the others. The stay application is before us.
Stay application and leave to appeal?
No, Abdul Sukur expired.
Substitution is there.
No, Abdul Sukur substitution is not there. Only appellant number 1 and 7.
Expired, you have to file a substitution application. Do you need to say this to you?
Now, substitute the 21, Lordship, the Asele Bibi, he is the relative of my learned friend's client.
All his heirs are on record.
Yes, Asela Bibi is heirs on record. But Abdul Sukur, Lordship, he has to substitute it.
He was the contested defendant in the standard trial court.
Has to be. The affidavit of service filed today be kept on record. Full stop. It transpires that Abdul Sukur, comma, the respondent number 22 has expired in the meantime in terms of the submission made by learned counsel for the appellants. Full stop. Next para. Accordingly, leave is granted to the appellants to take appropriate steps for substitution of the heirs and legal representatives of the said deceased respondent number 22. Full stop. Next para. Since respondent numbers 14 to 17, comma, who are the other contesting respondents in the code below, apart from Abdul Sukur, are already on record, comma, no further service need be effected on the respondent numbers 14 to 17. Full stop. appropriate orders shall be passed in respect of the heirs and legal representatives of the previously contesting defendant stroke respond number 22 as and when the substitution application is filed, comma, if the same is allowed. File an appropriate application. Substitution after
let
setting
the
aside
respondent
abatement.
number 21 be expunged because already expired, but his heirs is already on record.
Do you agree to that?
No, no, no.
No, you
21,
file an
after the-
application for that also, Mr. Mukul. Since it is
Number
submit,
18.
since it is further submitted by the appellants that
Yes,
respond number
18
20,
expired.
respond number 21 has also expired.
21, sorry, 18th is expired. Who is the relative of my learned friend?
The mother of the respondent number 14.
Her heirs are record on record.
Her heirs.
21 has not died.
No, 21. Sorry.
যেটা বললাম since it is further submitted by learned counsel for the appellants that the respondent number 22 হবে না 21 হবে না. Respondent number 18 has also expired in the meantime, but her heirs and legal representatives are already on record, comma, which factum is not disputed by learned counsel appearing for the respondent numbers 14 to 17, comma, the respondent number 18 be expunged from the records, full stop, appropriate corrections to the memorandum of appeal and the applications shall be carried out by the learned advocate on record for the appellants by deleting the name of the said deceased respondent number 18 during the course of the day. Let the matter go out of the list for the present with liberty to the appellants to mention the application for substitution and stroke or setting aside abatement and stroke or condonation of delay as and when the same is filed. Whenever you file it, mention it, we'll include it. Give a copy to Mr. Ghosh. Mr. Ghosh, in the meantime, you can take instruction whether you can appear for those years also.
But let me take.
If you can, otherwise we'll have to direct service
Because
to expedite.
another
because
advocate appeared before the learned trial.
if
But,
possible, through your client, you can take instruction. If
I can take it.
at least somebody should appear so that we can expedite because you are the worst sufferer due to this appeal. So we can do whatever we. Yes.
Number 18.
আগের দিনও কেউ appear করেন?
The application.
You are appearing?
Yes, no. Yes.
Condonation application has been filed?
Yes.
Well, the
17 days delay.
application has been served upon me just now.
Just now?
But
Mr. Ghosh,
but my lord, I am not admitting the statement that has been made in paragraph 6 and 7. Delay of 17 days. My lord, your lordship do not record my.
Understood. Can 6 of 2025 is an application for condonation of delay of about 17 days in preferring the appeal. Pushed up, heard learned counsel for the heard learned senior counsel appearing for both the parties. Pushed up, we find from the averments made in the application that sufficient cause for the delay has been explained. Accordingly, can 6 of 2025 is allowed on contest, comma, thereby condoning the delay in preferring FAT 313 of 2020. Pushed up, let the said appeal be deemed to stand registered and admitted accordingly. No arrest to cause. Pushed up, we shall the
other applications is of mine, my lord. So far as injunction is concerned, that is can 5 of 2025.
You are seeking an injunction?
Yes, I seek an injunction, my lord, during my lord.
This arises from what sort of a decree?
Suit for partition, my lord.
Preliminary degree?
Preliminary degree. My lord, they are
Injunction হয়েছিল তো? Order হয়েছিল?
There was an interim order of injunction passed by your lordship's court, my lord. That is
in connection with this application?
This application.
So dispose of this application. You have served all?
Yes. They have received. They have received, my lord.
Very well.
My lord was pleased to pass an interim order also.
I will dispose of this application, extending the interim order, and will direct you to put in requisition the other directions. Can 5 of 2025 is now taken up for hearing. Full stop. The said application has been filed by some of the respondents seeking an injunction in terms of the prayer made therein. Full stop. Next para. We find from the records that an ad interim order was previously granted on the said application, which is still subsisting. Full stop. From the affidavit of service, which is filed today and kept on record, comma, we find that effective service has been already done on the opposite parties in the application. Full stop. Accordingly, can 5 of 2025 is allowed, comma, thereby restraining the you have paid against the appellants only or the other?
Only against the opposite parties number 42 and 43, not against the appellant.
Restraining the What are the respondent numbers of those people?
Well,
Respondent also same.
Respondent numbers, my lord, 46 and 47.
Restraining the respondent numbers 46 and 47 within bracket, opposite party numbers 42 and 43 in the present application, bracket closed, and their men and agents from making any construction over the suit properties, comma, thereby changing the nature and character of the suit property in any manner whatsoever till disposal of the appeal. Push up next para. There will be no orders to cost. Next, the appellants shall put in postal costs and other requisites for service of notice of appeal on the
But it has been disposed,
deposited. Those directions were given. Last line take it. A liberty to the parties to mention the appeal as and when the same is ready for hearing.
My lord, I appear on behalf of the applicant.
Appearing for the first time, this you have served on the response. Where is the service?
Admitted and directed Honorable Justice Madhuresh Mishra.
First appeal, there is no admission.
Directed us to serve.
All have been served. You have checked up, all have been served. Only one. There is only one track report.
Well, we have served 2 times. Initially served appeal and the applications to the respondent number 1 and 2, but track report is not available. Thereafter, further served.
But this also shows only one track report regarding service on one. Please check up. Eta din ekbar onake. We find only one track report there.
Husband and wife, my lord.
Even then you had to serve. They were appearing together in the court below.
They were appearing and contested the suit, filed the WS. Written statement was
Joint WS.
Joint WS, but did not contest the suit.
That is different. So this arises from what sort of a suit?
Money suit, my lord.
Decree was granted against you.
On the ground
Yes.
that we have submitted all the certified copy, but it was dismissed on the ground that we have not submitted the original documents. The original documents lying with
The money claim was on what basis?
my lord. The respondent number 1 was the was an officer of LICI. He misused his official position and misappropriated 9,54,000 and odd and deposited the death claim of the policyholder and deposited the amount his wife's account.
Achha. So why was the money decree passed then against you? The court held what? That he did not do that.
The ground that we have not submitted the original document before the learned court below. My lord, authority initiated the disciplinary proceeding and dismissed him. Thereafter,
But then also, what is the explanation for the delay?
delay has been 269 days delay, my lord. Delay has been explained. First time the learned advocate appearing before the learned court obtained the certified copy of the order.
Oh, missing from the legal
Yes,
department.
my
and all.
lord. Missing from his official record, and thereafter further approach before the learned court and obtained this.
The present appeal, we are allowing this, section 5. The present appeal arises out of a money decree. No, 1 second. You say joint written statement was filed. How can it be? They must have been the plaintiffs.
Plaintiffs. No, LICI plaintiff.
You filed the suit for what? You filed the suit for?
Recovery of rupees 5 lakh. And
That was dismissed then.
that was dismissed.
Say that. The present appeal, the present appeal arises out of the dismissal of the appellant's suit for money. Push up, the appellant claims that the respondent number 1 was an officer of the appellant LIC and defalcated several sums of amount by transferring the dues of one of the clients of the LIC to the account of his wife, comma, the respondent number 2. Full stop. It is submitted by learned counsel for the appellants that the respondents are spouses and contested the suit jointly by filing a written statement together. Full stop. Subsequently, comma, however, comma, the respondents did not contest the suit, but the same was dismissed due to non-filing of appropriate papers in support of its claim by the appellants. Full stop. Next para. We find from the affidavit of service filed today, comma, which is kept on record, comma, that one of the respondents have been served. Full stop. However, comma, since the respondents filed joint written statement in the court below and appeared to the same learned advocate, comma, particularly keeping in view their relationship as husband and wife, comma, we are of the opinion that service on any one of the respondents tantamounts to service on the other as well. Full stop. Accordingly, we deem that proper service has been effected and take up can 1 of 2023 for hearing. Full stop. Upon a perusal of the averments made in the application, comma, we find that during the relevant period, comma, certified copies were obtained in time, but those were subsequently misplaced from the records of the legal department. Full stop. Due to certain other unavoidable paraphernalia, comma,
Not from the legal department, my lord, from the office of the learned advocate who was appearing before the learned court.
come to para 10 of your application.
Well, necessary papers were missing from the, but certified copy missing from the advocate chamber.
আচ্ছা তাহলে যেটা বললাম were misplaced from the department কি legal department বললাম legal department of the appellant না করে ওই জায়গাটা legal department থেকে কেটে দিয়ে from the office of the learned advocate appearing for the appellant at the relevant juncture. Full stop. Moreover, comma, certain necessary papers such as photocopies of the written statements and other relevant papers were also missing from the legal department of the appellants. Full stop. Thereafter, comma, due to necessary paraphernalia, thereafter, comma, or thereafter, comma, the appeal could not be filed in time and there is a delay of about 269 days in preferring the appeal. Full stop. Being satisfied of the sufficiency of the explanation given for the delay, comma, we allowed can 1 of 2023, comma, thereby condoning the delay in preferring FAT 72 of 2023, full stop. There will be no arrest to costs, full stop. The appeal is deemed to stand registered and admitted. Full stop. Next para. Appropriate order means will direct you to put in the postal costs and expedite the hearing of the appeal. There is no scope of stay of dismissal. Very well. Can 2 of 2023 is an application for appropriate orders, comma, in the nature of directions for expeditious hearing of the appeal, full stop. Accordingly, can 2 of 2023 is also disposed of by directing the appellant to put in the postal costs and other requisites for service of notice of the appeal on the respondents within a fortnight from date, full stop. The trial court record shall be called for by special messenger at the cost of the appellant, comma, also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of the arrival of the trial court records on the learned advocate for the appellants, full stop, appellant, full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. But do it within a fortnight because it's LIC you have given a fortnight instead of a week. But put in the postal requisites and the special messenger costs. Yes, next. Thank you.
Application for restoration.
Within time? Within time, within 30 days.
It was fast.
24 to 2025. Yes, within time.
Well, order first and
Who is for the you are for the respondent? Within time, so we are allowing this restoration application. The can was dismissed for default. Can was for what? Can 4?
Can 4 was for another distribution application.
This time pay some costs.
So, my lord, he's coming through legal aid. My client is coming through legal aid, and not only
Then we will
that,
impose costs on the advocate who appeared. You are appearing all along.
kindly, if you lordship will see my explanations, but actually, my lord, I was zeal from the previous day, and
You miss the advocate.
my
You were there. And
yes, and I annexed the doctor's prescription.
if you say an advocate is ill, court does not insist on doctor's prescriptions. We can reject the application for annexing the
My
prescription.
bona fide, I have annexed.
We should reject the application for having lost faith in court. Anyway,
No,
Can 5 of 2025 is an application for recall of an order dated February 24, 2025, whereby Can 4 of 2024 was dismissed for default. Full stop. Can 4 of 2024, comma, it may be noted, comma, was also an application for restoration. Full stop. Next para, heard learned counsel for the parties. Full stop. Although we are somewhat disappointed with the second dismissal for default, comma, we find from the submissions made on behalf of the appellant that the appellant comes through legal aid and take a lenient view in the matter, comma, more so since learned counsel appearing for the appellant, comma, who had been appearing at the relevant juncture as well, comma, personally submits that he was himself indisposed at the juncture when when Can 4 of 2024 was dismissed for default. Full stop. Accepting such contention, comma, Can 5 of 2025 is allowed, comma, thereby recalling the order dated February 24, 2025, whereby Can 4 of 2024 was dismissed for default and restoring Can 4 of 2024 to its original file and number. We are taking up Can 4 as well. So that was within time. Can 4 টা আছে আজকে লিস্টে দেখ। Can 4 be listed tomorrow for hearing? কালকে দিয়ে দেবেন।
Along with the Can 3, Can 3 is the injunction application. What is happening there? Milord, during pendency of the appeal,
Very well. Can 4, both are of which year?
Can 3 of 2020 and Can 4 of 24.
Acha, the Can 4 of 2024 as well as Can 3 of 2020 be listed together for hearing tomorrow.
Yes, my lord, there is a direction, my lord, that all interim order to be vacated.
Acha, যেখানে
there is no interim order.
There's
no interim order.
Let us just check up.
There is no any interim order.
If any interim order.
No, that order is not there in that. We have not recorded anything of that. যা আছে তাই। Thank you. কালকে ওই দুটো can দিয়ে দেবে। Can 3 আর thank you. Please come back tomorrow for Can 3.
Item number 21.
I am the respondent. Respondent. You are for which of the respondents, Mr. Devnath?
Respondent 1, 2.
I am for the plaintiff appellant petition.
3 has not appeared as yet. The office report says that.
No, 3 has appeared, my lord. I know that advocate, but at this point, my lord.
Office report says he has not filed any wakalatnama till date.
Let he appeared.
Appeared without filing wakalatnama does
can't-
not carry any meaning. That is the office report.
Well, one thing, my lord. Here, my lord, what happens that only simple suit for partition were filed by my client that was dismissed on the ground of non-maintainability.
Why not maintainable?
According to learned court, that is barred by the res judicata. Well, that may be, my lord, paperwork has already been prepared. Everything is ready. If your lordship kindly.
Everything is ready, but apart from appearance of respondent 3, there are only 3 respondents here.
No, another thing,
They
today I
also
filed an
1 and 2, Mr. Devnath.
Yes.
Also, they have filed an application for addition of parties.
Because one of the 2 pro forma parties have been missed out from the cost title.
In the cost title.
Therefore, I
the
want
name
to.
was not written there, but in the body of the petition itself, they have stated.
Yes, 2 persons.
What is that Can?
That is Can 5, State of West Bengal, and 1 Ajuzul Lashkar that have been missed out from the cost title.
Can 5 is for extension of interim order. Can 4 is for addition.
Can 4.
Can 4, Mr. Devnath, should he allow?
Addition of parties, my lord.
They have not contested.
They were omitted because they were there in the court below.
They were in the plaint. At the first stage, it was dismissed without taking evidence.
Yes, but they were parties in the court below.
Pro forma, yes.
fellow. Can 4 of 2025 is an application for addition of parties. Push up. The parties sought to be added were left out in the memorandum of appeal, comma, although they were defendants in the court below. Pushed up. Learned counsel for the appellant submits that no relief has been claimed against. What about Ajijul Loskar? Who is he?
One of the co-sharers, my lord, in the
Co-sharer at
no
partition
relief has
suit.
been claimed.
Partition suit itself is
No, my lord,
claims
your lordship go through the
co-sharer, every co-sharer against every
He is
co-sharer.
just occupying the adjacent plot. They, he is a,
But he is a co-sharer.
not co-sharer.
You
He
said
is-
co-sharer.
No, not co-sharer. He is assigning the owner of the adjacent plot. How to avoid complication, he has been made party.
Yes, Mr. Devnath, is he correct?
My lord,
Kindly send a copy of the
he's
plate.
the owner of another plot adjacent to my.
Yes, not co-sharer. Subject to, yes, pro forma in the trial. court.
Claimed against the uh, parties sought to be added in the code below. Pushed up. Next para, in such view of the matter, comma, upon hearing learned counsel for the parties, comma, can 4 of 2025 is allowed, comma, thereby adding the state of West Bengal represented by collector, comma, South 24 Parganas at Alipur, comma, Kolkata 7,27,000 and Ajijul Loskar, comma, son of Ataul Loskar of Newtown, comma, post office Diamond Harbour, comma, district South 24 Parganas, comma, pin code 7433331 as pro forma respondents to the present appeal. Pushed up. Since no relief has been sought against the said respondents, said pro forma respondents in the code below, comma, neither are they alleged to be co-sharers in the property, comma, we dispense with service of notice of appeal on the said respondents. Pushed up. Next para.
The 3 also did not contest it in the
He
trial.
did not contest.
No, my lord. Contested by 100 clients. On the
We
ground.
also find from the records that respondent number 3 hearing did not contest in
Yes.
the suit in the code below, comma, which was dismissed at the outset as not maintainable.
My lord.
Push up. Next para. In such view of the matter, comma, we dispense with service of notice of appeal on the respondent number 3 as well as the added pro forma respondents. Push up. In view of appearance of the respondent numbers 1 and 2, comma, who contested in the code below, comma, we dispense with service on the said respondents as well. Pushed up. Accordingly, the appeal be treated to be ready as regards
Paper is ready.
service.
The order January 4th, 2024. The direction is given to filing the paper.
Yes, paper was ready. I will file day after tomorrow.
Ready but not filed.
No, ready.
The appellant shall file the requisite number of paper books in terms of the order dated January 4, 2024 within a week. Within 1 week.
1 week.
Within a week from date. Pushed up. The time for filing paper books is extended accordingly for a week from date. Pushed up. Records are before this court, obviously.
My lord.
And also, my lord, the copy to me also.
Yes, certainly. Appeal be ready listed for hearing. My lord, only short point. Otherwise, I could not have disturbed your lordship.
1 week.
No, not right now. Not
My lord, kindly add. My lord, kindly add. This only short point.
The liberty is granted to the appellant, comma, upon filing of paper books and service of copy thereof on the learned advocate for the appearing respondents, comma, to mention the appeal for inclusion in the list for hearing. Not right now, Mr. Das.
Take back the order.
And another application for extension of interim order. That is can 4. Sorry, 5, my lord. Interim order granted by this honorable court has been
only to maintain status.
status quo.
That was the original order passed.
Yes, my lord. By honorable Mr. Justice Division Bench, presided.
Can 1 was disposed of? The original injunction?
No, pending. Therefore, subsequently, it has been extended by the.
We have filed an application for
vacating.
That is also pending.
Status quo only order, my lord. That was extended subsequently by.
Can 5 of 2025 is an application for extension of the interim order of status quo granted earlier. Pushed up. Can 2 of 2023 has been filed by the contesting respondent numbers 1 and 2 for vacating the said interim order. Pushed up. Upon hearing learned counsel for the appearing parties, comma, however, comma, we find that unless the parties maintain status quo with regard to the suit property, comma, the appeal may be rendered infructuous before being heard out finally. Pushed up. Accordingly, we dispose of can 1 of 2023, comma, can 2 of 2023, as well as can 5 of 2025 by extending the ad interim order of status quo granted earlier till disposal of the appeal. Full stop. Next para. আর কিছু প্যারা নেই, no orders to cost. You have to file the paper books and give copy to Mr. Devnath.
Well, only the one thing before I
No, not now.
Short question, well, only short.
So many short questions crying for being heard. Yes. 22, yes.
Your Lordship, Mr. Surya Prasad Chattopadhyay is appearing for the respondent. Our
Nothing doing.
clerk's
You are
father,
there?
no, Your Lordship, our clerk's father had passed away last night, Your Lordship.
Mr. Chattopadhyay's father?
No, our chamber clerk's father. So if Your Lordship kindly takes it up tomorrow, that will be really.
On the prayer of, you are for which respondents?
All.
On the prayer of learned counsel for the respondents, the matter is adjourned for the day. Please give your name. Don't give the name of Mr. Chattopadhyay.
No, Your Lordship.
My Lord, I
Your
appear
Lordship,
for the
appear for the
respondent.
petition, Your Lordship.
My Lord, on 17th March, my Lord, I extended the time for the appellants, my Lord, to file their affidavit and reply by 2 weeks. We have been served a soft copy of the affidavit and reply, though it's termed as a supplementary affidavit on Saturday. My Lord, but I would beseech my Lord to take up the matter for hearing, my Lord. Nothing much is there in the reply.
What is appearing before us? Which of
My
the
Lord, can 2 was being heard. Can 1 has already been disposed of, my Lord. My Lord had
Your
passed a
Lordship.
conditional order of stay.
Can 2 is for recall of what
Based on
modification?
the order that Your Lordship had passed.
Where is the order annexed at page? Which page of the can 2?
Yes, Lordship. Yes.
First annexure.
First annexure, page 26, Your Lordship. No, not page 26.
11.
Yeah, you got it. Page 11.
Page
Yes.
11.
So what was the nature of the order passed there?
Indicated-
ADR occupation charge আছে condition.
Occupational charges, Your
Lord
Lordship.
has already vacated this order by a subsequent order because they didn't fulfill any of these conditions. So perhaps this can, as it is, my Lord, it stands
If you
infructuous.
have vacated subsequently, then
Already
there is
vacated
no question of further modification. This is a vacated order. It does not exist now.
The interim order was, the protection was vacated, Your Lordship.
Protection was vacated subsequently by a subsequent order. This, when did we vacate it?
Yes, my Lord, I'm just. We kindly take up 24th February 2025. 24th February 2025. Para 5. Para 5.
Your Lordship.
Issue of non-payment,
Yes.
you have vacated.
Non-payment,
So there is
yes.
a scope of.
Your Lordship, this can application, Your Lordship, is in regard to the modification of the occupational charges, Your Lordship. We were joining
no
issues to
scope
the
of that,
amount that
because
was.
on the basis of that you have already vacated the order. Now that has attained further finality. No question of vacating that. That order has merged in a subsequent vacating order. So you have rather affirmed in a sense that order by vacating it.
That department.
After vacating, post vacating, we cannot modify our order, thereby recalling our vacating order also.
Lordship, it was for us filed earlier, Your Lordship, and we just.
Could have been, but you were heard. In your presence, it was vacated. We find from 24th February order.
24th
Mr. Saurajit Dasgupta, Shaunak Banerjee, Ashish Chaudhary, Uma Bagri. So Mr. Mukhopadhyay has a ball. Nothing to do apart from pointing this out.
This application, Lordship, was perhaps filed earlier, Your Lordship, and thereafter, due to non-payment of the charges, Your Lordship, therefore
No.
that part of the order was.
No.
Your Lordship,
Necessary directions were passed regarding the appeal.
Appeal,
Paper
my
books
Lord,
and all.
yes, my Lord. The original order itself, my Lord, had passed those directions. My Lord,
So
and-
try to
my
have the appeal heard.
Yes, my Lord.
No,
Your
we'll
Lordship,
hold
would
that.
kindly, Your Lordship, would kindly hear out this application, Your Lordship.
We are hearing it. We have heard it.
The can application, Your Lordship, in
Can
regard
too.
to Your Lordship, in regard to the amount fixed as the charges.
No, we
Your
cannot
Lordship.
do that now. After vacating it on that ground, we'll give our reasons. That will be the reasons.
But also one submission, I'll just indicate on merits of the application as well. It's really a review in the guise of a modification application.
No, Your Lordship, I beg to
I'm
differ,
just-
Your Lordship.
my Lord,
We'll
My Lord,
record the submission,
Your
but
Lordship would
dismiss
kindly.
it on some other ground.
Your
We
Lordship
won't
would kindly
entertain
not.
that.
Your Lordship would kindly not dispose the application today. Your Lordship
No.
kindly. Your Lordship being led.
last 3 occasions time has been sought.
Your
I
Lordship,
insist,
I'm
my Lord,
being.
today has-
No.
Your Lordship being led by a senior advocate. Lordship kindly
Who is
hears
that
me out.
senior advocate?
Mr. Mukherjee, Your Lordship.
Which Mr. Mukherjee?
Mr. Probal Mukherjee.
No, no.
Your Lordship,
Listen.
kindly hear me out, Your Lordship. And Your Lordship, in the last
Explain to
occasion, we
Mr.
have been
Mukherjee.
given, in the
We
last
explained
occasion,
to Mr. Mukherjee, his name was taken, but we did not concede.
in the last occasion, Your Lordship had granted us to file the official reply as well, Your Lordship.
File your reply. We'll take that on record.
So,
File that reply. We are not precluding you from filing a reply. You have filed your opposition earlier.
Yes, Your Lordship, there's one indulgence I would like to pray, Your Lordship. The typing error in the first page, Your Lordship, it was.
We'll gloss over. The affidavit in reply. The affidavit in reply filed in respect of Can 2 of 2024 filed today be kept on record.
It will be 2025, my lord. Can 2 was filed in 2025. There's that is also an
Oh,
error on
sorry.
the
Can 2 of 2025 has filed today be kept on record. Full stop. Next para. The present application bearing Can 2 of 2024 has been filed for recalling stroke modifying the order dated December 18, 2024, whereby stay of operation of the impugned decree of eviction was passed on condition of payment of certain amount of occupation charges by the appellant. Push up learned counsel for the appellant. Mr. Mukherjee is in the court premises.
That I am not aware.
Then we'll not record his name.
Grateful.
Then we'll not refer to him as a senior advocate.
No, Your Lordship.
Learned counsel for the petitioner submits that that on the grounds as made out in the application and the affidavit in reply, the order dated December 18, 2024 be modified by reduction of the occupation charges payable in respect of the suit premises. Who's up next para? Learned counsel appearing for the respondent
decree holder.
Respondent submits that the said order dated December 18, 2024 has merged into the subsequent order dated February 24, 2025, whereby this court had vacated the order of stay passed on December 18, 2024 due to non-compliance of the condition of the same, since the appellant failed to deposit the area occupation charges as well as electricity up-to-date electricity charges in terms of the said order. Full sub next para. Upon hearing learned counsel for the parties, we find that in view of the initial ad interim order dated December 18, 2024 having already been vacated by the order dated February 24, 2025, in presence of learned counsel for both parties, on the specific ground of non-compliance of the condition of the grant of stay as imposed in the order dated December 18, 2024, there is no further scope of setting back the clock by recalling or modifying the order dated December 18, 2024. Full stop. In the event such a prayer is to be permitted at this juncture, the same would tantamount also to recall the order dated February 24, 2025 in the absence of any challenge against the same. Full stop. In any event, we do not find any convincing reason to modify the order dated December 18, 2024, since the points raised in the present application, if adjudicated, would amount to a reconsideration of the order under recall on merits afresh, which is not permitted within the scope of a modification application. Full stop. Accordingly, Can 2 of 2025 is dismissed on contest without any orders to costs.
Obliged.
Sorry.
Your Lordship, the whole purpose of this application was if the order could have been a bit recalled and the amount that was decided could have been reduced a bit.
Obviously, that was the only purpose. That was the only purpose, whole
comply.
purpose, whatever you say. But there's a hole in the purpose.
Yes. Grateful.
I am for the applicant. But as per your lordship direction, I have sent the copy of the application.
What is the endorsement there?
But endorsement address left.
Left, then you have to serve afresh. You're enjoying interim order, go on
But-
enjoying the interim order.
But the respondent reside another place, my lord, not on the same.
Give that address.
Yes, I have.
No, you have to carry out the correction. Which respondent was not served?
Both.
So you have the fresh addresses.
Yes, yes.
So we'll give you leave to incorporate the correction and serve afresh. The affidavit of service filed today be kept on record. Full stop. It indicates that proper service could not be effected on the respondents, comma, since they have changed address in the meantime. Full stop. Learned counsel for the appellant is appellant submits that he has been furnished the current address of the respondents. Full stop. Accordingly, leave is granted to the learned advocate on record for the appellant to carry out the necessary correction in the memorandum of appeal and the connected application bearing can 1 of 2023, thereby incorporating the current addresses of the respondents. Full stop. Such amendments to the memorandum and the application shall be carried out during the course of the day. Please do it in both the judges. Full stop. Fresh service shall be affected. Fresh service of the amended application bearing can 1 of 2023 shall be effected on the respondents, indicating that the application shall next be listed on May 7, 2025, when an affidavit of service to that effect shall be filed by the appellant.
I'm grateful.
Thank you. Please send a corrected copy. In the copy also, you just carry out that correction and then send it. Yes, Mr. Boral.
I'm for the applicant.
What have you come up with? Section 5.
There's a section 5 application. There's the 3 applications are there. Section 5 for the first
Appearing
time.
for the first time.
For the first time.
We will serve copies of all the applications. Will direct you. The appellants shall serve copies of all the applications on the respondent, indicating that the applications shall be listed for hearing on May 7, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Yes. 26, my lord, I'm for the appellant.
Right.
My lord, respondent, directed for service, they're appearing.
Both the respondents.
Yes, ma'am.
Right.
They're brothers.
What is the application about?
My lord, this application.
You have
has
put in
been-
this deficit court fees and all.
Yes, ma'am. Leave
Legal
to-
representatives,
Yes,
that
ma'am.
defect.
Yes, my lord. That for that application has been filed, ma'am. This is the can application.
Leave to prefer appeal. When did the demise occur? After the trial court
After the-
decree?
Yes, ma'am.
What is the appeal against? What decree?
My lord, partitions.
Preliminary decree.
My lord, the appellant has filed a partition suit that has been
Dismissed.
Dismissed, my lord.
So we allow this.
My lord.
Can 1 of 2024 is an application for leave to prefer appeal against the heirs and legal representatives of the deceased plaintiff, comma, who met his demise between the filing of the present appeal and the impugned decree of the trial court dismissing the appellant's suit for partition. Full stop. Upon hearing learned counsel for the parties, comma, can 1 of 2024 is allowed, comma, thereby granting leave to the appellants to prefer the present appeal. Full stop. Necessary amendments to the memorandum of appeal shall be carried out by the learned advocate on record for the appellants, incorporating the name of the said parties during the course of the day. Since you are appearing, we will pass necessary directions for the appeal to be heard. Next para. In view of the appearance of the respondents through their learned advocate, comma, service of notice of the appeal on the respondents is dispensed with. The trial court record shall be brought by special messenger at the cost of the appellant, comma, appellants, comma, to be deposited within a week from date. Full stop. The trial court shall, comma, however, comma, retain skeletal records for proceeding with the final degree proceedings. Full stop. Next para. The appellant shall.
Has been dismissed. Has been dismissed.
Oh, sorry. last sentence টা skeleton records টা কেটে দাও। Sorry. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants, who have liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for hearing. Thank you.
Item number 27.
My lord, in item 27, my lord, I would like to make a humble prayer. The application for condonation of delay has reached the clients a few 2 or 3 days prior, and I have not been able to go through it. Neither have the clients been able to get in touch.
Which district?
Nodia, my lord.
So
if
that has to be allowed first, so we'll give them some time.
The application has been served upon the clients, but
Yes, we understand.
Yes.
Both the applications have been served.
No, lordship,
Only
only for
the-
condonation of
Only the
Acha, this file that affidavit of service. Affidavit of service filed today be kept on record. Full stop. Learned counsel for the which respondents?
Surojit Bishwas. I don't even.
You have served on all the respondents.
Yes, lordship.
Learned counsel appearing for the respondent number 3 seeks an adjournment since the said respondent could not hand over the copy of the application for condonation of delay, comma, although the same has been received by him, comma, to his learned counsel. Full stop. Accordingly, we adjourn the matter till when? Today we are on Monday. Well, next Tuesday.
Yes.
Adjourn the matter till May 6, 2025, when it will be listed under the same heading, along with Can 1 of 2024. If we allow the section 5, immediately thereafter we'll take up the acha, we'll direct you to serve. No, we cannot do that because you are for only one of the. Mr. Das, we have he's asking for time, although they have received copies. We have kept it on 6th. 6th. Next Tuesday.
Let them not sell, transfer, or alienate in the meantime. Because it's a suit for partition. Has
Take up
been
the
dismissed.
injunction on the next day. একটা কাজ করো লাস্টে যেখানে বললাম can the application along with Can 1 of 2020 jars.
Grateful.
Shall be listed next. We'll pass an identity model in the next.
Yeah.
Don't transfer in the meantime. Please just instruct your client to do that, Mr. Chakur.
Great.
You are late or not late? Yes.
For now, I am not late, man.
We will ensure that you do the matter. Yes.
Grateful, man.
I'm for the appellant wife.
Yes.
But I beg to appear for the respondent husband. My lord, instructions, my lord, if your lordship
Alimony
could direct this matter to be sent to mediation, we want to explore the possibilities.
You are agreeable?
Lordship, two things there. One is from the date of knowledge, 18 days delay.
No, this is a challenge against what? Against
Challenging the ex parte divorce decree.
Acha. 18 days delay.
18 days delay from the date of knowledge. And the lordship, if your lordship please to grant an interim stay to the order. I am agreeable to his proposal.
No, my lord, I say this, my lord, only
So if you marry in the meantime, it will be difficult.
it's already done. We have waited for a period of time. In the month of July 2024, he has already contracted a second
Because
marriage.
I have aware of the order on 30th July 2024.
Right now, then difficult to send for mediation. We'll condone the delay and we'll direct you to file an affidavit in opposition, disclosing the fact that you have married.
But still, if we can explore the possibilities.
We are agreeable.
Let's, my lord, try once.
We'll condone the delay at least.
Yeah, condone the delay at least, my lord, and let's, my lord, deep sent to be for
Very
this
well,
mediation.
very well.
If there is a minor child lordship, minor daughter. Absolutely fabricated issue, lordship.
We'll consider that because there are serious charges also.
Several charges.
See whether this can be,
Because
the present appeal has been preferred against a decree of divorce obtained by the respondent husband, full stop. We find from the adjournments made in Can 1 of 2024 that sufficient reason for the delay has been made out. Full stop. Accordingly, upon hearing learned counsel for the parties, comma, Can 1 of 2024 is allowed, comma, thereby condoning the delay in preferring Why FMAT?
Initially, it was FMAT. Subsequently, decree has been deposited. It was FAT 77.
Thereby condoning the delay in preferring FAT 77 of 2025.
2025.
there'll be no order as to cost. Full stop. The appeal be deemed to stand registered and admitted. Full stop. At the juncture when the application for stay bearing can 2 of 2024 is sought to be moved, comma, it is submitted by learned counsel for the respondent husband that the respondent has already contracted remarriage in the meantime. So be that as it may, comma, learned counsel for the respondent gives a proposal for the matter to be sent to mediation for resolving the dispute between the parties either way. Full stop. Learned counsel for the appellant, comma, on instruction, comma, submits that he has no objection to the same. Full stop. Accordingly, the matter is sent for mediation to the mediation committee of this court to explore the opportunities of mediation. Full stop. The file be sent at the earliest to the said committee for such purpose. Full stop. Liberty to the parties to mention the application for inclusion in the list in the event the mediation does not succeed. প্রথমে অ্যাফিডেভিটের সাথে সার্টিফিকেট
Deeply obliged.
এটা মিডিয়েশনে যাবে বলে
But I beg to of the appellant, all of the respondents have been served.
for all the respondents.
There is only one, and yes,
Two.
Yes.
What is the affidavit? You have already served.
Yes.
What is the application about?
But this is an application for stay
of
stay of the impugned order to the extent that the appellants
what was the degree?
The suit was for specific performance of an agreement for sale of a flat. That was that decree was not granted. But in the meantime, an advance payment was made by the plaintiff to the defendant by dint of the decree. That amount has been
directed to be refunded.
Lordship has stayed that part of the decree.
Otherwise, if you accept, then
yes, my lord,
the appeal goes.
So
we'll extend that stay till disposal of the to that part to that.
And Manoj formally issues notice of
Yes, everything will. You file a cross objection. Why didn't you file within 30 days of notice?
Manoj, notice has been for stay.
Technically correct. Very well. We'll record in our order that 30 days begins from.
Very well.
If the cross objection is against a finding under order 14 rule 33, you can now take without. Anyway, we'll not say anything on that. Can 1 of 2024 is an application for stay of operation of the impugned degree to the extent that the learned trial judge directed a refund of the consideration amount which had been paid by the appellants in terms of a purported agreement for purchase of the suit property. Full stop. Next para, learned counsel for the appellants contends that the appellants insist upon getting a degree of specific performance and as such in the event are compelled to accept the refund as directed, comma, the appeal may be rendered infructuous. Full stop. Upon hearing learned counsel for the parties, comma, we accept the proposition advanced by the appellants. Full stop. Accordingly, can 1 of 2024 is disposed of by staying the operation of the impugned decree to the extent that the consideration amount paid by the appellants to the respondents have been directed to be restored till disposal of the appeal.
Not part of the consideration.
আচ্ছা যেখানে যেখানে কনসিডারেশন বলেছি পার্ট অফ দ্য কনসিডারেশন নেক্সট প্যারা ইন ভিউ অফ দি অ্যাপিয়ারেন্স অফ দি রেসপন্ডেন্টস থ্রু দ্য লার্নেড অ্যাডভোকেট comma service of notice of the appeal on the respondents is dispensed with and it will be deemed that the notice of appeal operates from this day for the purpose of filing cross objection which according to learned counsel for the respondents, comma, the respondents seek to file. Full stop. Next para, the service of notice dispensed with করে দিয়েছি তার আছে next para হচ্ছে the trial court record shall be brought by special messenger at the cost of the appellants to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books, comma, incorporating the cross objection, comma, if filed by the respondents, comma, within 8 weeks from the date of service of notice of arrival of the trial court records on the learned counsel for learned advocate for the appellants. Liberty to the parties to mention the appeal and cross objection, comma, if any filed in the meantime, comma, for inclusion in the list as and when the appeal is ready for hearing.
I will submit my Vokalatnama written in court.
Liberty is granted to the learned advocate for the respondents to submit to file his Vokalatnama in the department during the course of, by tomorrow. Do it today.
My lord, item number 30, I beg to differ the respondent. My lord, before everything, I want to tender my apology. My lord, the opposition was directed to be filed. My lord, we could not file within time. I'm carrying one of the opposition, two opposite can one, which is for condonation of delay.
What
And,
about that?
my lord, that is being filed, my lord, and there is a stay application, my lord. My lord has also directed to file an opposition towards
What about that?
My lord, it is getting affirmed today, my lord. I'm just asking for liberty
You
by
must have not served copy of this also.
I have served a copy today itself, my lord.
My lord,
I shall be candid, my lord.
Kindly says can one. My only explanation was that the suit was decreed ex parte. I came to know when I filed a criminal matter. They came before the magistrate to
What
take
was the
bail.
nature of the decree?
My lord, divorce. Divorce granted against the wife ex parte only based on one document, a GD.
What is your the premise of your
My lord,
opposition?
the opposition is that, my lord, that my learned friend's client, my lord, was aware of the existence of the proceeding. The bailiff went to serve the summon upon the learned friend, and she vehemently did not take the service of the
But that
summons
is-
and affix the summons at the door of the
That is
of
regarding
the
the
appellant
suit.
before
I'm
your
saying
lordship.
It is on the expertise degree itself. That is on the merits of the case.
My lord, that's on merits of the case.
Oh, that pertains to the
Yes, my lord,
second
she
type
was
also.
aware of it, my lord, and she has came up before your lordship after
You use the reply
269
to
days,
this.
my lord.
Use the reply to this. Don't contract any remarriage in the meantime.
My lord, we have already contracted before they have filed the appeal, my lord. That is on record, my lord. On last occasion, it was submitted before
On
your
the prayer
lord.
of learned counsel for the appellant, the time for filing affidavit in opposition to can 1 of 2025 is extended till date, full stop. The affidavit in opposition so filed be kept on record, full stop. A copy thereof is served on the learned advocate for the appellant during here and now, full stop. Next para. The time for filing reply thereto is extended for a week from date. Full stop. Next para. On the prayer of the learned counsel for the respondent, the time for filing affidavit in opposition in respect of can 2 of 2025 is also extended for a week from date.
Well, it is getting affirmed today. So
Sir,
it can
kindly
be
give me
till-
2 days, my lord.
Very well.
Maximum 2 days, I shall serve it upon.
Is extended till April 30, 2025.
Grateful, lordship.
Full stop. The time for filing reply thereto is extended for a week thereafter. Full stop. Next para. The applications shall next be listed for hearing on May 13, 2025. May 13.
Grateful.
Sorry. Yes. এটা পড়ে গেলে আবার ভিডিও হয়ে যাবে ইউটিউব
Lordship,
হয়েছিল আমি একবার এখানে রাখতে গিয়ে পড়ে গেছিল সেটা ভিডিও ইয়েস সরি
Lordship, in item number 31, Mr. Shiva Prasad Mukherjee is appearing in this matter.
For whom?
For the appellant, Lordship.
Debanjan Mukherjee was appearing. Oh, Shiva Prasad Mukherjee was also.
Yes, Lordship.
Mr. Johnny Mukherjee?
Yes, yes.
What
Lordship,
about him?
Unfortunately, he is suffering from health issues. For that reason, we
When should he keep it? Tell us.
Lordship, at least a week's accommodation, Lordship, would be
On the prayer of the appellant, the matter is adjourned till May 6, 2025.
grateful.
Tuesday
Lordship,
week.
the affidavit of service may be
Affidavit
kept
of
on.
service filed today be kept on. You have served proper service effected.
Lordship, the service was restricted to only one respondent.
You have served him.
Yes, Lordship. There were 2 addresses. One was received and
One is sufficient.
Grateful, Lordship.
বলেছি তো affidavit service. Affidavit service filed today be kept on record বললাম. Yes.
This is my application, my lord.
So, three Bhattacharya in the same matter. Yes.
My lord, can
Bad matter. Nothing is.
No.
Yes.
My lord, can 1 is an application for stay. My lord had disposed of can 1 by holding that since this is an appeal from a money decree, deposit the my lord.
Decree is for modification of that. What is the modification?
Modification, my lord.
We had mentioned this.
Yes, half, my lord. I have, my lord, I have all taken loan from my relatives, my lord, and 8 lakh rupees was the decretal amount. Now, my lord,
Cultivator, Mr. Malay Bhattacharya.
4 lakh rupees, my lord, we could
Sir,
gather.
bad code for you.
My lord, I have received instruction from my client. The stands taken by my learned friend that he is now a day laborer. It is not a true fact.
Even cultivator.
My lord, it is said. But the facts remain this, my lord, he is still doing business of brick, my lord. That is
of
bricks.
Brick business.
Yes, my lord. This is my instruction, my lord. Now, my lord, rest upon your lordships, my lord, your lordship.
No, did you direct affidavits for
Yes,
this?
yes, if required, my lord. I can show, my lord, any documents regarding this, my lord. But this is the instruction received from my client that he's still
ready,
in
my lord,
business of
for-
brick, my lord.
Demand draft you have to deposit to the registrar.
Yes, my lord, 4 lakh rupees, my lord, we could gather from, my lord, from our, my lord, relatives, my lord, by taking loans, my lord, they have helped.
Have you disclosed about the brick business being closed here?
Yes, yes. Well, that is the impugned. That is recorded in the impugned order. Lord,
business
what
code,
is
it
this?
is
What is the fact of the case? Suit is, my lord, they had a, my lord, brick field which was given to me. The understanding was that I will, my lord, burn bricks and, my lord, sell them. And, my lord, I will take a portion of the, my lord, profit, and the rest will be given to them. They have, my lord, filed this money suit that I have not given, my lord, the remaining, the amount which in terms of the bricks sold. Now, my lord, they have filed two, my lord, one criminal proceedings and this suit for recovery of possession, recovery of, my lord, the money, my lord, from me on the same self ground. Now, my lord, criminal proceedings is still pending. My lord, I was in prison, my lord, for long period. Ultimately, bail was
Prison
granted.
also? For what? Cheating?
No. And for this case, they have approached my lord,
criminal-
criminal for 420.
425.
Now,
That
my
is
lord,
being deprecated now by the Supreme Court every day.
to
Cannot
parallel-
convert civil disputes to criminal.
Now, my lord,
And we have also been doing it previously. Anyway, let us talk.
now, my lord, it is recorded in the.
Yes, this will modify that.
Half of the amount, my lord, he paid for
Yes.
half.
4 lakhs, my lord.
Kindly fix, my lord, short date so that, my lord, hearing could be done, my lord. It is a matter of 2017, my lord. This order has been passed 2017, my lord. Kindly consider.
Those directions are there already.
No.
Paper
Kindly
books
see
and
your
all.
lordship's
No,
order.
paper book directions are null. Not there.
No, nothing.
You are appealing for how many respondents? Sir? One only.
Kindly see your lordship's order dated 10th February 2025, page 10 of the application.
Can 2 of 2025 has been filed for modification of the order dated February 10, 2025, whereby Can 1 of 2023, a stay application, had been disposed of.
No, pending.
Oh, Can 1 of 2023, a stay application, was taken up for hearing, and an ad interim order of stay was passed, subject to payment of the entire decretal amount, subject of deposit of the entire decretal amount to the tune of rupees 8,71,276 with the Registrar General of this court within March 10, 2025. Pushed up. In the present application, the appellant seeks remission of the amount by way of a modification of the said order. Pushed up. The appellant submits that in view of the brick business, which was the genesis of the money claim from which the present appeal arises, having stopped in the meantime, the appellant has been relegated to day labor, cultivating others' lands. Full stop. Next para. It is submitted that somehow, upon taking loan from relatives and acquaintances, the appellant could gather an amount of rupees 4 lakh, which is less than half of the decretal amount. Full stop. It is submitted that a concession be made in respect of the condition of the grant of stay by a modification of the order dated February 10, 2025 to the effect that the appellant may be permitted to deposit rupees 4 lakh as such condition. Full stop. Learned counsel for the appellant also submits that he is ready with the with a bank draft to the tune of rupees 4 lakh for the purpose of making such deposit. For sub next para, learned counsel for the respondent opposes such contention and submits that the brick business is still running. Full stop. However, on being asked, it is submitted that the plaintiff respondent is not in a position to file any document or other proof of such contention regarding continuance of the brick business. Full stop. Since it has been averred on oath in Can 2 of 2025 that the appellant is not in a position financially to put in the entire decretal amount as condition of stay, keeping in view the plight of the appellant, and also that in the event the direction to deposit the entire decretal amount is sustained, the appeal will be rendered illusory as a remedy before the appellant, comma, who is now in a marginalized position insofar as financial constraints are concerned, comma, we are of the opinion that the present application ought to be allowed. Full stop. Accordingly, Can 2 of 2025 is allowed, comma, thereby modifying the order dated February 10, 2025 to the extent that the amount to be deposited as condition for stay shall be rupees 4 lakh. Full stop. The time for filing such, making such deposit is extended till tomorrow, and the order dated February 10, 2025 is modified to such extent as well. Full stop. Next para. The other conditions and observations in the order dated February 10, 2025 remain, and in the event such deposit is made, comma, the Registrar General of this court shall invest the same in an interest-bearing account with any nationalized bank. Full stop. In the event the Registrar General is approached by the learned advocates for either of the parties, comma, the particulars of such investment shall be disclosed to the said learned advocates. So we are disposing of this stay application. In view of the above order, comma, we dispose of Can 1 of 2023 by making the stay order absolute, comma, recording that subject to payment of subject to deposit of rupees 4 lakh with the Registrar General as per or above order by tomorrow, comma, the operation of the impugned judgment and decree shall remain stayed till disposal of the appeal. Full stop. In view of the appearance of the respondent to learned advocate, comma, service of notice of the appeal on the respondent is dispensed with. Full stop. Next para. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing.
One small thing, Milord, in the order dated 10th February, it's recorded that the judgment, impugned judgment shall remonstrate. It's now, Milord, the money execution case number 1 of 2008.
আচ্ছা, যেখানে আজকের অর্ডারটা দিলাম, stay of operation of the impugned judgment and decree as well as connected execution case, if any. So we covered that also.
Yes, grateful. Great.
33, my lord, I have the defendant appellant, my lord.
My lord, I do appear for the respondent plaintiff, my lord, I am opposing, my lord.
Defendants of the appellants give your lordship, my lord, suit for recovery of possession, my lord. My lord, the appellant number 1 is a separate tenant, my lord, while appellant numbers 2 and 3 are holding a separate tenants. The plain case is that the
How can there be a separate tenancy regarding the same property, Mr.
that appellant number 1 has got a tenancy under the under the plaintiff, my lord, the respondents herein.
Yes.
And the appellants number 2 and 3 have got another tenancy.
Self-same property.
Self-same property from another proportion. Now the plain case is that, my lord, the 2 suits are being filed, my lord, against the 3 suits are pending so far as the eviction of the tenants are concerned. Now in this plain case, they have made out a case that the tenants have encroached certain portions beyond their tenancy and made certain illegal construction. For removal of those illegal construction and eviction.
This suit is for only for that. Your trespass. Achha.
Well, this suit has
what is the reason for the delay?
Reasons for the delay, my lord, the appellant number 2 was suffering from cancer. My lord, the others were looking after him, my lord. He could not approach court in proper time, my lord. So 243 days delay. Furthermore, there is an ex parte decree. The appeal is against an ex parte decree.
My lord, we kindly take up that section 5 application first, my lord. Whether there was a
have explained, my lord, from
whether they have a sufficient cause for condonation of the delay.
There are 6 page 4 onwards, my lord. We have explained.
Let my learned friend please that section 5, then I will, my lord. There is a scope for condonation.
Well, the decree was passed behind the back of the petitioners, and the petitioners were subsequently.
You learned in the first week of August 24.
My lord.
Immediately you applied for certificate. Already.
Well, thereafter, my lord, on 14th August, my lord, we applied for certified copy, and we got the same, my lord, on 30th of August 2024, my lord. Thereafter, my lord, due to the since the petitioner number 2 was suffering from cancer, my lord, steps could not be taken, my lord. Medical certificate have been annexed, and thereafter in the month.
But you don't. You are not required to stay 24 hours beside the patient.
Well,
what happened between this August and you filed it in March 2025? What happened between these 7 months?
Well, he is suffering from blood
Who is
cancer.
suffering? We fully sympathize with that. But what about 1 and 2, 1 and 3?
But so far as 1 and 3, the case made out is, they were looking after the petitioner number 2, and as such could not contact the client. Initially,
not a
they
good ground at
contacted,
all.
certified copy was obtained. Thereafter,
No, we are only asking from August 30, 2024, when you obtained the certified copy.
Blood change.
Before that, we are not even looking into that. What about the 7 months after that?
He was taken to Bombay, so far as the evidence is concerned, page 9 onwards, the copies have been annexed,
Have you stated that he was taken to Bombay and all these?
As such, yes.
But you have annexed documents which show he was taken to Bombay.
Entire family members has to accompany him.
I am told, the entire family members accompanied with him, that is the reason, for the delay. Although, the certified copy was obtained much prior to,
7 months prior.
7 months prior. Thereafter, these things intervened, subsequently, there was a delay.
But if you see these pages all pertain to February 2025.
February.
What treatment are
What happened between August and February? Everything happened in February.
No. He's.
There are other dates also. Let us see. You have to show us that the entire period was covered. The length of delay is not important, but because page 17, only page 9, if you find that is 27th of February 2025, which is 6 months after the obtaining the certified copy.
Right.
And if you come to, what should I say? If you come to page 17, 17 is of February 2024 for an earlier period. Much earlier period.
The last annexure, so far as page 18 is concerned, my lord, it's much earlier, my lord, January from
No,
January,
not only the 17 to 19, all much earlier.
my lord, January 2024 to my lord, February 2027, my lord, the papers have been annexed.
No, we find from the papers
Answer on and from
17 to 19 all relate to January 2024 or February 2024, which is 1 year prior to this, even prior to passing the degree paper. We don't know.
Kagojats.
And the only document which you have annexed for the relevant period is page 9, which is of 27th February.
27th February.
So which is just immediately prior to filing of the appeal almost.
My lord.
What happened between these 6 months? There is no explanation whatsoever.
Well, so far as the 6 months is concerned, my lord, he was detected, my lord, subsequently, my lord.
Detected.
Although, my lord, the documents ought to have been annexed, my lord. May I sum my question?
No, there is no other person in the family. You have not even explained in your application.
But may I file a supplementary annexing all the documents?
The entire period.
My lord.
Entire.
So that will permit that.
My lord, will kindly see once that application, as rightly pointed out by my lord.
No, he has
The
not.
last two documents pertains to a period of February.
No, don't repeat whatever you have said. We will permit them to file supplementary affidavit.
My lord,
We find from the application for condonation of delay that although it has been pleaded that even after the obtaining of the certified copy of the judgmental degree of the courts below in August 2024, during the 7 months in between the said date and the filing of the appeal, the appellant number 2, who is a septuagenarian and a cancer patient, was being looked after by the other appellants. First up, it is submitted by the senior counsel for the appellant that throughout the period, the entire family was engaged in looking after the treatment of the appellant number 2, who had to be taken to Mumbai for his treatment as well. First up, however, as rightly pointed out by learned counsel for the respondent, we do not find the relevant papers supporting such contentions apart from a medical document dated February 27, 2025. Full stop. The other documents annexed primarily pertain to periods much prior to the relevant period, and as such cannot be germane for adjudication of the present application. Full stop. At this juncture, the appellant, learned senior counsel for the appellant, seeks leave to file a supplementary affidavit annexing all relevant documents for the entire period of the delay. Full stop. Despite the respondents having opposed such prayer, we find that for the ends of justice, an opportunity ought to be given to the appellants to file a supplementary affidavit. Full stop. Such affidavit shall be filed within a week from date with an advance copy to the learned advocate on record for the respondents. Full stop. The matter shall next be listed under the same heading on May 7, 2025.
we will file a short affidavit to the whatever they disclose because we have documents to show what.
Next listed on May 7 na kore, next listed on May 21, 2025. Full stop. The respondents shall file their affidavit within bracket S in opposition to the application and the supplementary affidavit within May 14, 2025. Full stop. Reply, if any, shall be filed by May 20, 2025.
Before 19, before 19 to
Nothing doing. Hide the pendency of this. Thanks.
Lord, may I please, I'm appealing for all the respondents.
All the respondents. What is the application for?
I kindly seize your lordship's order dated 21st of April, my lord.
Illegible annexures.
Yes, my lord. I was directed
That
to
yes, sir. Not that yes.
comply, my lord. My lord, this is
What is the application for?
this is the application for injunction.
What is the appeal? The appeal arises out of?
It is against an order, my lord, dismissing an application for probate on the ground that it is not maintainable before the learned district judgment.
Why not?
Lord, no reason has been given. It says it's a jurisdiction.
It was contested.
It was not contested, my lord. It was an ex parte order by the learned district
So then
delegate.
it had to be before the district delegate. It is before the district delegate.
It was, the probate was granted by the learned district delegate, my lord. Against that order granting probate, a revocation application was filed by my client before the learned district judge, which was at the very threshold dismissed on saying, my lord, that holding, my lord, that there is jurisdictional error. If your lordships have the impugned order, my lord.
Yes, let us see that.
My lord, that would be at page 63.
Page 63 is the order, my lord.
Yes, we are looking at the certified copy itself from the memo. No, if it's passed by the probate is granted or dismissed by a judge below the level of the district judge, then an appeal lies before the district judge. So therefore, you went directly before the appellate authority with the revocation case.
Before the
Should have been before a parallel forum. Why not?
Before the district judge, because the district judge, learned district judge, has the authority, my lord, to revoke a probate, my lord.
Let us just look into the provisions.
The
Succession Act into Indian Succession Act. Indian Succession Act.
Not I do.
ডিসিজের কাছে নরমাল কোর্সে যাওয়ার কথা, তবু দেখে নিচ্ছে।
My lord, kindly have, my lord,
yes,
section 264 for once, my lord.
Right.
Page 63. List of dates of
Please come to section 388.
388. My lord.
Please read it.
Investiture of inferior courts with jurisdiction of district court for purposes of this act. The state government may, by notification in the official gazette, invest any court inferior in grade to the district judge with power to exercise the function of a district judge under this part. My lord, I will emphasize under this part, my lord. That was part. My lord.
District delegate. District delegate.
My lord, this issue has been settled by your lordship, my lord. I am fortunate enough to have a copy of the judgment. If your
No,
lordship-
you're right about the part also.
Your lordship permit me, I can place the judgment in which your lordship
We'll
has
come to
settled the
that. No,
issue.
no, we were looking at whether this could be decided right now instead of, I mean, drawing them into long drawn litigation.
Not your lordship kindly. I'm just handing over the list of dates, not your lordship.
No, not list of dates. It's a question of law.
Your lordship kindly see the primordial prayers made in the application. That is at page 10. Page 10, Lord, your lordship kindly come to page 10. This is the prayer in this appropriate application. His primordial prayer is this. The aforesaid circumstances, the applicant most humbly prays that your lordship may graciously be pleased to set aside the order number 3 dated 17 January 2025.
So they have amended that with leave of court and sought for injunction also.
Your lordship kindly.
Amended copy was not served on it?
No, that
Yes,
was not
served, my
served.
lord, served.
Amended copy.
Copy was served on the last occasion.
That is the that has been
So
served.
now they've sought for injunction. That primary prayer is not no longer there.
No, Lord, let me read out the orders of.
No, not that. Let us come to the section because he has only said that he does not have jurisdiction. Why?
No, Lord,
does he
it's
not have
part the order. He said, Lord, your lordship kindly see the.
Your learned friend is right because we were wrong there. We were relying on, 388. But 388 pertains to that part only which deals with succession certificate. This is not a succession
No,
certificate.
this is not a success. It is a probate. He has gone for revocation of probate. The
If
probate
it's a
order has
revocation
been passed by the Lord, your lordship. That is at page 63.
Even if it's passed by the district delegate.
District delegate, 63, page 63.
Now, 264 confers power on the district judge to
Lord, your
grant
lordship,
or revoke.
your lordship kindly see page 63 order. It starts from page 62, Lord. It is under challenge.
Yes.
And, an application under section, I'm reading from page 62, my lord.
62, yes.
Page 62. I'm writing from an application under section 263 of the Indian Succession Act 1925 has been filed by the petitioner, namely such Ashif Ali, supported by an affidavit against such and such. And will was executed by the father of the petitioner as well as of the respondent, Lord. Invoking the order dated 7/2/2023 passed by the learned civil judge, Junior Division, Bishnupur in miss case number 18, miss case number 18 of 2021 on the ground stated district judge. The case preferred by the appellant is beyond the time limit. The certified copy of the order in miss case number 18 of 21 has been filed, court fees such and such duly executed Okalatnama. Petitioner did not file any petition praying for condoning of delay in filing the instant miss case number such and such. Then, Lord, your lordship, I am just skipping over an application under section 263 of the Indian Succession Act. Petitioner Asif Ali is supported by an affidavit against the praying for seeking an order of 7/2/2023 passed by the learned civil judge, Junior Division, Bishnupur in miss case number 18 of 2021 on the ground stated therein. The case preferred the applicant is beyond time limit. Certified copy of the order. Then I am skipping over the line. Petitioner did not file any petition praying for condoning the delay in filing the instant miss case. Then, Lord, your lordship, kindly come to page 62. Order number 7, page 63. Order number 03 dated 17/1/2025. That is under challenge. What I was just referring to. Record is put up. Learned advocate for the petitioner have submitted an application stating inter alia that the order of probate was passed by the learned civil judge, Junior Division, ex parte. But this is not an ex parte order. Paper notification was there. Notice was served upon them. They did not appear.
The deemed degree was ex parte, obviously.
Ex
parte means in the absence of the other side.
But notice has been served.
Even then, it's an ex parte degree.
Ex parte
If
degree.
I served notice and they do
However,
not
they
come,
did
it's
not
an ex
appear.
parte.
Then, Lord, your lordship kindly see ex parte. The petitioner has filed the revocation application there. Now learned advocate has prayed to send the application for proper forum. It reveals that ex parte order of probate was passed by the learned civil judge junior division Bishnupur, but without moving any application to set aside the ex parte order before the concerned court. That is Order 9 Rule 13. If at all any ex parte order has been passed, there is a provision. Your Lordship, I am coming. Perhaps my learned junior friend will be citing Justice Bhattacharya as his Lordship then was.
That is different.
That is different. Then Your Lordship can come. They filed an application.
No,
for
satisfy on the
revocation,
law,
such
not on
application-
judgment. Now, who has the power to revoke a probate? This is not an Order 9 Rule 13 application.
No, that
That was a mistake
what
committed.
judgment he referred, he has given me a copy of that. I have seen that.
We are
That is
not looking at that at all. Let us see from the statute itself.
But what is my suggestion? If this matter is remanded back to the district judge for reading afresh, hearing afresh, this is
On
my
merits,
suggestion.
on merits.
On merits.
No, if we accept your suggestion, we have to set aside this order. But this,
Let
we
it
have
be
to be
heard.
satisfied on law also.
And let it be heard by the learned district judge who has got the power under the law afresh. If
So
my learned junior friend
on
has got
consent,
no
we are
objection,
taking up the appeal itself for hearing, and on merits, we are passing that order. Not recording your, should you record your consent on that or judgment also?
No.
We are not recording consent on, we are recording consent only on the appeal being taken up along with the application.
Along with the application.
Only on that.
On that.
In view of the short.
In the meantime, no injunction order as your Lordship says.
No, we will not pass any injunction order. In the meantime, you will have liberty to.
Kindly grant me that liberty to pray for an injunction because already an eviction suit is pending
already
on
it
my
has been-
whatever we are
Whatever it is, that
material
will come.
matter lock, stock, barrel.
Yes.
In view of the short conspectus of the appeal, comma, upon hearing, on consent of the parties, comma, the appeal is taken up for hearing on the papers before us, along with the connected application. Push up, the limited question involved in the appeal is whether the learned district judge, comma, who dismissed the application of the appellant for revocation of a grant of probate ex parte, comma, had the jurisdiction to take up the revocation case in connection therewith. Pushed up by the impugned order, stroke deemed decree, comma, the learned district judge dismissed the revocation application on the ground that he did not have jurisdiction to take up the same, and that the appellant ought to have gone before the court which had granted the probate. Push up, we find from the records that the probate was granted. The court which granted, which dismissed the probate application.
Granted the probate application. Which granted.
Granted the probate. So next para, we find from the records that the probate was granted by the learned district delegate ex parte, comma, in view of there being no objection to the grant of probate at that stage, comma, since none appears for the persons on whom citation had been made, who are the present appellants. Next para, learned counsel for the appellant submits that section 264 of the Indian Succession Act 1925 confers jurisdiction on the district judge to grant and revoke probates and letters of administration in all cases within his district. Next para, upon hearing learned counsel for the parties, comma, we find that section 264 comes under part 9 of the part 9 to Roman 9. Part 9 of the said act. Although under part 10 dealing with succession certificate, comma, section 388 of the act speaks about investiture of inferior courts with jurisdiction of district court for purposes of this act and grants power for such purpose, comma, on the district delegate as well to pass appropriate orders for grant or revocation of succession certificates, comma. No such similar provision is found under part 9 of the act, comma, whereby the district delegate has the power to entertain revocation cases in respect of grant of probate of wills. As such, comma, upon hearing learned counsel for the parties, comma, that the learned district judge erred in law in observing that it did not have jurisdiction to take up the application for revocation of probate under section 264 of the Indian Succession Act 263 of the Indian Succession Act 1963 and consequentially dismissing the appeal, dismissing the revocation case. Full stop. Hence, comma, FA 144 of 2025 is allowed on contest, comma, thereby setting aside the impugned judgment and deemed decree dated January 17, 2025, whereby the appellant's revocation case was dismissed and remanding the matter to the learned district judge, comma, Bankura for rehearing the said revocation case on merits in accordance with law. Push up next para. It is made clear that this court has not gone into the merits of the respective contentions of the parties in respect of the case made out in the revocation application, and it will be open to the learned district judge to decide all issues in accordance with law. Full stop. Next para. Liberty is granted to the parties to seek appropriate interim orders before the learned district judge upon remand. Full stop. Consequentially, can 1 of 2025 stands disposed of as well. Full stop. There will be no order as to costs.
On the last occasion, your lordship passed an order on 26th March of 2025. There was an order of injunction, Lord. That order
That
is
was still disposal of the application.
Still there.
Now the application is gone.
Just one thing, if I may indicate to your lordship, that in the application, my learned senior friend was right in pointing out that there is a challenge. There is a challenge, my lord, to order number 1, which records, my lord, that the appeal was time barred. My lord, I respectfully submit, my lord, that it cannot be a time barred. My lord, time is under residuary clause, my lord, which is 3 years, my lord. So, my
It's an open, my lord has already given an opportunity. It is open to the
it is
open to the
Since
petitioner
I
to
challenge
go
it
and
before your
challenge
You are right on that because the judgments say that at best it can be taken as a suspicious circumstance. Delay 137 applies, but suspicious circumstance. But since we remanded back to the stage when it was dismissed for having no jurisdiction, that question remains open. That was not conclusively decided, was it?
No.
It was
Or not maintainable.
it was
আচ্ছা আরেকটা লাইন অ্যাড করে দিন it is further clarified that the issue of whether the revocation application is barred by law of limitation is also kept open to be decided by the learned district judge.
Last line of the order, my lord, your lordship can see the
So
last
the
line of
previous
the-
order it was there.
order number 1, my lord.
Last line of the order on 17th of January, my lord.
137 does not apply. 137 applies. Previous position was it does not apply. Then lastly, it has been held by the Supreme Court. 137 applies, but it will not be an absolute bar of limitation.
Right.
But it will operate as a suspicious circumstance. More the delay, more the suspicion. So there is no absolute bar of limitation.
Not the ground, what has been taken in the 263 application.
My lord,
That is on merit.
That is on merit.
I have the
That
honorable
is on
Supreme
merit.
Court judgment on this point, my lord.
We know the judgment. So we are not deciding that issue.
It
We have
will be
kept that
hard
open.
afresh by
Cite the
the
judgment before the district.
that will be hard afresh by the
That is kept
district-
open, yes.
kept open.
I'm so grateful, my lord.
Act applicable.
35, my lord, I am for the appellate.
You are for the appellate?
Yes.
This is appealing for the first time.
Yes, appealing for the first time.
What is the decree against which you have preferred the challenge?
My lord, this is not the decree, my lord. This is the order under section 25 of the Guardians and Wards Act, my lord.
Why FAT?
FAT, my lord, this is my lord, first appeal, my lord, because of, under section 47 of the Guardians Wards Act, the my lord, appeal lie before the High Court.
Yes, but it will be a miscellaneous appeal because appeals against decrees only are regular first appeals. It has to be declassified.
Yes. There is the defect, my lord. Kindly see what are the defect, my lord. What is the defect?
Check. You have checked up what are the defects? What are the defects? Instant appeal finds the genesis is judicial miscase, hence wrongly classified. Exactly that is the defect pointed out. So rightly so. We find that the present appeal has been preferred against an order passed, a final order passed under section 25 of the Guardians and Wards Act 1890, whose substance the impugned order is not a decree, comma, no regular first appeal lies, push up. The provision of appeal contemplated in the said statute speaks about an appeal against such an order, push up such an appeal, comma, being from an order, comma, has to be classified as a first miscellaneous appeal. Full stop. Accordingly, the office is directed to reclassify the appeal as a first miscellaneous appeal and allot an FMAT number thereto accordingly. Full stop. Such exercise shall be completed within a week from date. Full stop. The appeal be next listed for hearing under Order 41 Rule 11 of the Code of Civil Procedure on May 6, 2025.
But the department.
It party dite
But
hobe.
I'm saying the department to correct the memo of appeal. But in the
For what?
second page, my lord, it has been typed application under section 25 of the Guardianship What's Act. That is not correct. Appeal under section 47 of the Guardianship What's Act.
Very on the prayer of যা বললাম তার সঙ্গে on the prayer of learned counsel for the appellant, comma, leave is granted to the learned advocate on record for the appellant to carry out the necessary corrections to the memorandum of appeal during the course of the day. ওনাকে দিয়ে উনি কারেক্ট করি তারপর পাঠিয়ে দেবেন ডিপার্টমেন্টকে বলবেন এক সপ্তাহের মধ্যে কিন্তু আবার ফিক্স করেছি ওটা যেন করে দেয়
করে দিচ্ছি
Yes.
36, I beg to appear for the respondent. Defendant respondent. On the earlier occasion, my lord, there was a direction to file affidavits. Now, my lord, the impugned judgment, my lord.
What about the appellant, the petitioner? Who appeared for the petitioner?
Mr. Mahato, probably.
Mr. Mahato was hurriedly running to the other building when we came by our ferry to this court. He must be somewhere stuck up there. So we'll adjourn the matter for the day.
My lord, would it be my lord's kind sanction to take it day after tomorrow?
Yes, yes, why not?
Or other matter.
Affidavit in opposition filed on behalf of the respondent opposite party numbers 1 to 3 today be kept on record. Since none appears for the appellant, comma, let the matter stand over till April 30, 2025 when it will be listed under the same head.
My lord, there is one small difficulty, my lord. It was our duty, my lord. On the earlier occasion, my lord has recorded that we are appearing for respondent number 2. But fact lies, my lord, respondent number 2 has died and all the legal heirs are on record. We seek to appear for respondent number 1 and 3.
আরেকটা লাইনে অ্যাড করে দিতে যা বললাম তারপরে learned counsel appearing for the respondent numbers 1 and 3 points out that the respondent number 2 has died in the meantime, although the heirs of the said respondent are represented, the heirs and legal representatives of the said deceased respondent are already appearing in the present appeal as respondent numbers 1 and 3. Full stop. Accordingly, the learned advocate on record for the appellant is directed to expunge the name of the respondent number 2 from the memorandum of appeal and the connected application by tomorrow. Full stop. The order dated April 1, 2025 be deemed to stand corrected to the effect that the appearance recorded for respondent number 2 should be read as appearance on behalf of respondent numbers 1 and 3. Please intimate this order to Mr. Mahato immediately so that he can carry out the correction, expunging, deleting the name. You have served copy of the opposition.
No.
Yes, Mr. Gupta, what is the matter
This
about?
is that matter of with respect to the property at Uluberia, where with regard to that receiver application, your lordship was pleased to pass an order permitting the plaintiff to obtain police.
Yes,
police
boundary
order.
wall.
Yes, but we have served them, and they are appearing.
The challenge, the appeal is against receiver refusal.
Yes.
So the appeal has become infructuous. Basically, we'll decide the appeal, dispose of the appeal.
But already the
All has been built.
Yes, my lord. Pursuant to your lordship's last order, my lord, that is the 8th of April 20.
We'll continue that order.
Yes, my lord.
What was the order?
Pursuant to this order, my lord, this is the last order. Their purpose for this application, my lord, under order 40 rule 1.
Paragraph 7 onwards of my lords.
We hereby grant liberty. You approach and you have got police help. You have got police help. We'll extend that liberty. Extend that liberty. We'll keep that liberty alive. Dispose of the appeal without interfering with the impugned order.
That has not yet been done.
Yes, we have not.
They'll do it. No difficulty. Whenever they choose. But
No, no, we have approached, but whether we've got police help, that is.
No, we are not, I mean, we are not saying
I
anything on
understand.
that. If you have not done, if you have not.
No, no, we have done.
Your wall, you will build.
I am sure whether the police help and the wall has.
Your wall, your police, provided you pay.
But one thing, my lord, in the last order of your lordship, that is 8th of April, my lord. In the second paragraph, my lord, in the last line, that your lordship mentioned that in order to implement an injunction order, my lord, prior to this injunction order from this court, my lord, these application under order 40 rejected by the learned trial court, my lord. This injunction came later on after rejection of this application under order 40.
Because yes, ma'am, that is what I had indicated. Because in the order impugned, the ground of rejection refusal is
On
indirectly.
consent, we are taking up the appeal and the application together and extending this. On consent of both parties, comma, the appeal and the application are together, taken up together for hearing in view of the short ambit of the same. Push up, the appellant sought appointment of a receiver to oversee the construction of a boundary wall by the appellant on the appellant's property. Full stop. Such prayer having been refused by the impugned order, comma, the present appeal has been preferred. Full stop. We find that the premise of the appellant in seeking receiver primarily is to implement primarily is to ensure that the appellant is permitted to build the boundary wall in question around its property. Full stop. Next para, learned counsel appearing for the respondents points out that the injunction order granted by the trial court in favor of the appellant.
No, no, injunction order was not granted, refused.
Acha.
Injunction order by this honorable court.
Oh. That this court also granted before that.
No, could your lordship give me half a minute?
No, 1 minute. The injunction order granted by this court
Yes.
was
10th of February 2020.
Was after refusal of order 40 application.
Yes.
Acha.
Order
Because
40
initially order 39 was rejected. On that basis, order 40 was rejected.
That the injunction application, that the injunction application of the appellant was refused by the trial court, against which an appeal has been preferred. Push up in connection, the appeal is pending, injunction appeal is pending.
No, it's disposed of.
Push up in connection with the appeal, comma, this court granted the prayer for injunction. Full stop. Next para. It is further submitted that the receiver application was filed prior to this court, sir. Prior to the injunction order being passed by this court. Full stop. Next para. Be that as it may, comma, the purpose of the injunction and the appointment of receiver sought by the appellant overlap each other, comma, since both are for the purpose of ensuring that the appellant may build a boundary wall around its property without any hindrance from the respondents. Full stop. Next para. We are of the opinion that for such purpose, comma, no appointment of receiver is necessary. Full stop. In fact, comma, in view of this court, comma, in appeal, comma, having passed an order of injunction, which can very well be implemented by the appellant by seeking appropriate police help, comma, there is no further necessity to appoint a receiver for the self-same purpose. Full stop. Accordingly, FMA 331 of 2025 is disposed of without interfering with the impugned order.
No, my lord, your lordship has been pleased to, my lord, set aside on the last two. No, but no, not set aside, not set aside. But because
not even stayed.
No, no, your lordship will kindly set aside because the premise on which order 40 was dismissed was order 39 being dismissed. So, my lord, if this stays, then, my lord, again.
Without interfering with the impugned order, but with the observation that in view of subsequent grant of injunction by this court, comma, it will be open to the appellant to seek appropriate police help for implementation of the said order of injunction before the trial court. Full stop. Next para. In the event such an application is made before the trial court, comma, the learned trial judge shall dispose of the same in accordance with law, and, comma, in the event any infraction of the injunction order passed by this court, comma, into which the previous refusal of the injunction order has since merged, comma, is established, comma, such police help shall be granted to the petitioner. Full stop. Next part, it is made clear that even irrespective of any application for police help being filed before the learned trial judge, comma, the appellant will be at liberty to seek police assistance for implementation of the order of injunction passed by this court in the previous appeal. Full stop. If so approached, comma, the concerned police authorities shall act on the server copy of this order and grant such police help for the purpose of implementation of the order of injunction passed by this court in what is the previous appeal number?
FMAT 213.
FMAT 213 of
2024.
2024. FMAT 213 of 2024. We have stated that that refusal has merged into this.
Yes, but only two submissions, my lord, because I had
Can
made
such
this,
as can one of 2025 is accordingly disposed of as well? No, no orders to cause. Yes.
only two submissions which your lordship considered on the previous day and passed the order. First is, my lord, I had indicated the plight which my client was suffering before the lower court, for which we were constrained to now file an application under clause 13 to have the suit transferred. Because, my lord, there is the fourth round of appeal.
That is on a different. We have said that.
No, my lord, your lordship has directed us to go before the trial court to file an application for police help.
Yes.
But that is what.
Irrespective of that, also you can approach the police. You have given that liberty also.
Yes.
You can directly approach the police also. You can file an application.
And
or
one other, possibly it's my apprehension.
No, trial court means whichever trial court, if it is transferred to some other court, that means the trial court.
But my lord, one other apprehension. My lord, if your lordship is specifically recorded
You have said
without
that
interfering with the
yes.
order passed under order 40 rule 1. But my lord, if your lordship sees the order, the entire substratum of the order
Findings cannot be challenged. The premise was ultimately the conclusion was that the receiver was refused.
Yes.
That's why we are not interfering. But we have observed, Mr. Gupta, that the refusal of previous refusal of injunction has merged with the High Court's injunction order. So that takes care of your apprehension. And you can approach the police directly on the strength of this court's order, or approach the trial court with a police help application. If that is done, if there is an infraction, it will be granted. We have virtually allowed that if there is an infraction.
Grateful.
এটা ওকে বলে দিতে একটু যে এই অনিন্দিতা আর আপনাকে দুটোই অ্যাপিল ডিসপোজাল হয়ে গেল, কিন্তু একটা আগে এফএটিটা হলো অ্যাপিল ডিসপোজাল হয়ে গেল, জাজমেন্ট ফর্ম, এটাও জাজমেন্ট ফর্ম, জাজমেন্ট ফর্ম। Yes. Yes.
It is that matter, Millard, where I have been, Millard, trying to contend that so far as my subtenant is concerned, it is supposed to give back possession to me. Now, Millard, there are two suits. In one suit, Millard, both the injunctions have been passed, confirming the order of injunction till disposal of the suit. Against which this.
By now we have forgotten the facts of the other.
I'll reiterate. Obviously, Millard.
Because
Obviously.
it was fresh in our mind still a few days
Yes,
back. But
obviously, Millard. I'll try and recapitulate. But I know this court, Millard. It will take me 5 minutes for your
no,
lordship.
definitely, Mr. Dotto, we gathered that on the last occasion it was submitted that
order 41.
So there is something in between that the possession was handed over and again handed.
Yes. Now, Millard,
That is the only difference.
Let me tell your lordship, Millard. So far as the first suit is concerned, the hearing is concluded, Millard. There, Millard, we had shown to the trial court that there are documents to show that even after the letter on which they rely to say that possession has been handed over to them, eviction notice and other documents will show that they are still operating from. My subtenant is still operating from there. And on that basis, Millard, the learned judge proceeded on the basis that possession has to be ascertained, but for the time being, the property needs to be protected. That was one aspect. So far this matter is concerned, Millard, I can say with some amount of responsibility, Millard, that once I concluded the argument in the previous matter, Millard, both parties stood up and said that the facts are identical. In fact, Millard, to Millard, ascertain that, Millard, I checked the written notes of submissions which they have filed. The written notes of submission
In the other matter.
In the other matter, which is before your lordship, now we have today, Millard, is also the same. So it is an identical thing. So the representation given to the court, Millard, with all due respect to the learned judge, Millard, was that both matters are identical. Now, my lord, when it came up before this court, my lord, when I got an opportunity to look into that matter, I found out, and my learned friend also pointed out, that there is a difference. The difference, in fact, is that here they have pleaded that after getting a lease, they have entered into negotiations with my subtenant, and they have entered into a lease, and thereafter the subtenant had surrendered the property, and therefore they are in possession. This is the difference. But this fact was not argued. I can say this, but my lord, since this point has been taken before the appellate court, we took out an application, my lord. We could lay hands on a document, and we took out an application on the last occasion, my lord, saying that we had still now, because there also the possession claim to be 2023. But the document which we could lay our hands on shows that my subtenant is still representing to the public at large that it is still carrying on business from that premises. To that extent, my lord, we filed this application under.
Mr. Dotto, it was at the hearing stage, even on the last date. This was also on the hearing stage. Now, on the hearing board, why should you entertain an order for 2027 to reopen the entire thing?
I'll tell you, lordship. The way I need to put it is this, my lord, your lordship will look at the document. If your lordship feels that without looking into the document, justice can be done, lordship will do it.
We appreciate what you are saying, but at this stage, should you reopen this thing?
Well,
I mean,
that,
should not
my lord,
even be. If this was a final degree against which you have come up, definitely you wouldn't have any other forum.
Final in confirming what?
And this is an injunction order at the end of the day.
Injunction order.
But now, at the hearing stage, why should you reopen? Even if they are giving out, that does not conclusively prove that they're in possession also.
No. If the person, so my lord, let's take it to that extent that it's not conclusive. At interim stage, injunction stage, nothing is conclusive.
No.
So, my lord, it's all prima facie case, balance of convenience. If it is prima facie case, balance of convenience, then, my lord, in that case, my lord, your lordship will have to see the interest of both the parties are protected till this goes
Mr.
out.
Dotto, but on the last occasion, it was, I mean, this was about to be, this was also about to be disposed of.
I only want.
It was, an adjournment was taken probably because the facts are identical or not, that was to be ascertained.
I'll tell you, lordship, my lord, that adjournment was not taken. My learned friend had come back to state court that whether the facts are similar or not,
he would ascertain.
He would ascertain, and he said that the facts are even better here. There may be a
better. What we don't
whatever,
know, but
according to him, the facts
that
were
was
better.
the only reason it was adjourned. But otherwise,
And
it would be decided that
three authorities, and your lordship said that come back considering the authorities. So, my lord, since then,
after that order for 2027, I mean, you should have taken out this exercise at the point of time when the appeal was filed.
My lord,
or any time in between before it came up for
but
hearing.
we had knowledge of this subsequently. Though the my lord, having said that, I must say that it was in the website. But lordship, have a look at my lord. No point throwing judgments at the court until and unless the court is conscience is satisfied that. Kindly have a look at that document once. Your lordship can reject it, my lord, or my lord, your lordship will. But whether this document will throw any light on the issue before your lordship, considering the fact that this was not before the trial court.
Order for 27 টা আছে আমাদের কত নম্বর can কোন can
can 2
can 2 can 2 কোথায় yes
so my lord, this point was not before the trial court. It's coming of first time. So my lord, considering that,
when was the impugned order passed, Mr. Dutt?
I'll tell you. Impugned order
before this day, before May 26th. Must be after that.
Yes, after that.
So this was always there for you to.
Yes, my lord. The question is, as I said, your lordship, my lord, there are many.
4127 double A is not satisfied.
So, yes, but
I mean, you have to.
Even then, my lord.
What prevented you from taking this out previously?
Even then, my lord, the court has gone a little further, if I may. It's all about being satisfied whether this will be any of relevance.
Rather, it says it does not depend upon the relevancy of the issue.
Correct. However, at the same
not
time,
whether it's relevant.
However, at the same time, when the additional evidence sought to be about removes the cloud of doubt over the case, and the evidence has a direct and important bearing on the main issue in the suit, and the interest of justice clearly renders it imperative that it may be allowed to be permitted under
yes, definitely.
Such application may be allowed. Now consider Order 41, Rule 27B.
27B, Mr. Dutt, is the court, if the appellate court finds that it will be necessary for the court to look into that document to decide the appeal properly. I'm paraphrasing only.
The appellate court requires any document to be produced or any witness to be examined to enable it to produce judgment or for any substantial.
This cannot override double A.
No.
This is a double A situation. We don't require any further document to decide the issue.
But Millard, if Millard, it has.
Because you had produced certain documents regarding possession, whatever documents.
So far as the other one is concerned, so far as the first one, as the reason I say so, Millard, that the learned single judge also did not have the occasion to hear this matter on this point of possession.
What is your reason? I mean, what is the ground given in this application, Mr. Dutt, to show, I mean, why you couldn't produce this before? There are 9 only.
Incorrect.
You are exercising due diligence. Nothing is there.
Paragraph 3, Millard. The evidence sought to be produced is one letter of 26 May 2023 issued by the respondent number 2 to the principal such and such. The applicant submits that the letter of 26 May caught attention of the learner when during pendency of the appeal while he was searching for details of the pro forma respondent on the internet on 18th April 2025. During such research, the respondent came across a link in the website of Raigon Surendranath Mahavidyalaya in so. Upon clicking the link, it directed to the present letter of 26 May, which is already annexed here to the screenshot of the web page and collectively marked as Annexure A. The reason it shall appear from the letter of 26th May that the same has been issued on so and so date, and the address of the pro forma respondent is shown as 225F AJC Post Note. Such letter completely belies the stand of the appellant that the suit property was handed over on 11 March 2023 in terms of the letter of possession of the same date. The said letter establishes the fact that the pro forma respondent continued to occupy the suit property, and the entire case of handing over possession to the appellant is nothing but the sham made with the sole intent to mislead.
Rather, it says it's not functioning at present. WBI, West Bengal Electronics Industry Development is that subtenant. I mean,
no, this is the WLL division, Millard, at the top. WL, they have 2 divisions. WIL, will division.
Yes, whatever. The bottom and top are the same.
Yes, at the top, your lordship will find.
Only invite your lordship's attention, the risk of interruption, to just the 2 rubber stamps.
2 rubber stamps.
2 rubber stamps.
1 rubber stamp.
One is here. Because the address, they've retained their old letterhead, but because the address has changed, they put in the rubber stamp with their Salt Lake address.
So
and
therefore,
also at the bottom.
Yes, Mr. Dutt.
Yes, so therefore, Millard, one thing is clear that this document
Is Mr. Dutt known in the original side as Dutt and in appellate side as Dotto, or in both sides as Dutt?
He is Mr. Dutt.
No,
What does he call himself?
Dotto. So, Millard, now that my learned friend has stood up and expressed, Millard, his anxiety, the document is now, existence of the document has gone in.
This doesn't admit possession.
No, not possession. What I'm saying that there are 2 contrary stands before the court. There are 2 contrary stands before the court. Ask you. There are 2 contrary stands before the court on the question of possession.
This WB, this whatever this is, the top, this is the alleged subtenant.
Yes. That's division is the alleged subtenant. And the registered office, Millard, at the bottom, your lordship will find was, still is, and continues to be.
See the stamp at the top, as you pointed out.
Yes, development sense.
No, the rubber stamp between the date and LT, the letter number.
Yes.
That gives a Salt Lake address.
They have an office at Salt Lake. They always had an office at Salt Lake. There is no doubt about it.
This letter does not say, Mr. Dotto, where they want to open it.
No. What I am on is this.
They are saying that they're interested. They're writing to the principal of the Raigon Surendranath Mahavidyalaya.
Renewal of the agreement such and such.
This is the suit property. Where is this suit property?
225F AJC Post Road, Calcutta, at the top. Will division.
As per renewal of agreement, the computer center was running and functioning, not running. We are interested further to continue the training center at your college. So you are relying on this letterhead for the purpose of?
Yes.
Oh no.
Not on the contents of that letter. Not contents is somebody else, Millard. I can't even, Millard.
Oh, then on merits we can reject it. We'll give our reasons. The reason is that I am telling you this.
Lord, may I just
We'll say that this is not a proof of the possession of the suit property because of the contradictory thing here. That's contradictory stamp here also. One of the reasons.
So, my lord,
That's a letter.
so far as order 41 rule 27 stage I can cross, but on merits your lordship
We
is.
will say we don't require it, and you don't fulfill a criteria.
The other way, my lord,
Because we don't find that this is necessary for us to properly decide the appeal. Because of the reason, we will give the reason. Because according to us, this does not even, I mean, this is not a prima facie proof of possession regarding that.
No, it's an assertion of a fact that I
because-
still have an office.
Because all the letterheads, previous letterheads also show the same address, give the
Yes,
same
so
address.
it's an
So
assertion.
this does not improve the situation.
So
The other letterheads, they also speak about this address. This agency was this suit property address.
my lord,
And the bottom also says Salt Lake address.
the registered office is at Salt Lake. I'm not disputing that. What I'm on is that he is representing to the world at large, even after 11th of March 2023.
The Raiganj Surendranath Mahavidyalaya at large.
At large, that I have still an office over there. And my lord, my plaint proceeds.
They
on
don't
the-
say that, Mr. Datta.
and my plaint also proceeds.
They don't say they have an office there.
No,
The
WLA.
letterhead they're using. With a current rubber stamp must be more current.
My visiting card, if it says, my lord, my visiting card says that I have my
That is where that is the issue, Mr. Datta. If in your visiting card there is a subsequent rubber stamp showing a different address, the rubber stamp must be after the printing.
Yes. Yes.
It has to be after the original
Lord,
print.
let's take it this
So the
way.
current address is reflected in the rubber stamp.
There can be two possibilities. This letter was issued from Salt Lake office. The Salt Lake office had the rubber stamp and he put the rubber stamp on it. One possibility.
If there's a rubber stamp and
other
the print,
Anyway,
rubber stamp
Milord, it was
has to be the
printed at
latest.
Salt Lake, and since the signatory of the letter was aware of the fact, he had put his stamp on it. Entire thing has taken place in Salt Lake.
Maybe.
Other way of doing
And
it
the
is
signature also carries a rubber stamp which puts Kolkata 91 as the address, which is Salt Lake.
yes, the stamp of Salt Lake. The
No,
other way of looking
both the stamps at the top as well as the signature along with the
says West Bengal Electronics Division Development Corporation D59 Salt Lake Kolkata 1.
91.
And the
91.
and the next
If
says,
Salt Lake was Kolkata 1, we would be in Salt Lake.
oh, I'm sorry,
Right now.
91. Sorry, Milord. And
91, yes, you are right.
We could have been in Salt Lake.
And 91.
Then this would be Salt Lake.
This would
If
be Salt
Kolkata was, if Salt Lake was 7 lakh 1.
Saying
Or
that
the other way of looking
we
at
could
it.
have been in Salt Lake, Milord. Though we were supposed to go to Newtown.
Don't even think about it.
That is what, Milord, I have been hearing. As his manager told me when.
Many future generations will also
Yes,
hear.
yes. But
Yes.
I'm told, Milord, right now. Anyway, that's not.
Can I
deal with this.
derail him by?
No, please don't.
Let me derail him. That I am a personal, Milord, witness to this. I'll just take a minute.
Then go to the box.
No, Mr. Shomaraditya Pal was arguing, and on the other side was Mr. Anindo Mitro and Mr. Hirok Mitro. So, Milord, Mr. Shomaraditya Pal said something, Mr. Hirok Mitro stood up and objected. Why did you say that I said this? Mr. Pal's answer was, I said meter, not Mitro. Why are you responding? Mr. Dutt's example, Milord, brought that memory to more than 20 years old. May I also just hand up the written statement filed by Webel?
Yes,
Let us first decide this order for 2027.
This would
Order
be
for
necessary
2027.
also. Let him.
Because
We'll just decide this application, then take up the.
yes, I have nothing
for
to
hearing.
say really, apart from I want to put the written statement.
Heard learned senior counsel appearing for both sides on Can 2 of 2025, which is an application under application for Mr. Take your seat.
Oh.
An application for production of additional evidence in the nature of one under Order 41 Rule 27 of the Code of Civil Procedure. Full stop. Next para. Learned senior counsel appearing for the defendant number 2 stroke appellant number 1 submits. No, sorry. The learned senior counsel appearing for the appellant stroke petitioners submits that in the interregnum, between the appeal was last heard and today, the appellant has come across a letter issued by the alleged subtenant, namely West Bengal Electronics Industry Development Corporation Limited, in its letterhead to the principal of one Raiganj Surendranath Mahavidyalaya on May 26, 2023, which reveals that the address of the said alleged subtenant is disclosed to be the suit property situated at 225F, AJC Bose Road, 4th floor, Kolkata 7,20,000. Puts up next para. Learned senior counsel places reliance on the averments made in paragraph number 3 of the application and contends that the letter caught attention of the learned advocate for the applicants during pendency of the appeal while he was searching for details of the pro forma respondents on the internet on April 18, 2025, and that during such research, the respondent came across a link. Appellant should be appellant. The appellants came across a link in the website of the Raiganj Surendranath Mahavidyalaya being www.rs.
No, I am the respondent. It is his appeal. So, in
Sorry.
Applicant.
Very well. During such research, the respondent stroke applicants came across a link in the website of the Raiganj Surendranath Mahavidyalaya being www.rsmraiganj, Tana Choto Hater, Raiganj RAIGANJ.in. Upon clicking the link of which he was directed to the purported letter dated May 26, 2023, which is sought now to be produced as additional evidence. Push up, it is contended that from the letterhead itself, it will be evident that till May 26, 2023, the appellant, the alleged subtenant has been giving out to the world at large that it was still in occupation of the suit premises situated at AJC Bose Road, Kolkata. Push up next para, learned senior counsel controverts the submissions of the applicants. Learned senior counsel for the appellant stroke opposite parties controverts the submission of the petitioners. Push up next para, learned senior counsel appearing for the petitioners also relies on a judgment of such and such reported at 2000.
2002.
2022 7 SCC 247.
Paragraph 7.
Push up next para. By relying on the said judgment, learned senior counsel argues that although the general principle is that the appellate court should not travel outside the record of the lower court and cannot take any evidence in the appeal, as an exception, Order 41 Rule 27 of the code enables the appellate court to take additional evidence in exceptional circumstances. Full stop. It may also be true that the appellate court may permit additional evidence if the conditions laid down in Order 41 Rule 27 of the code are found to exist and the parties are not entitled, as of right, to the admission of such evidence. Full stop. However, at the same time, where the additional evidence sought to be adduced removes the cloud of doubt over the case and the evidence has a direct and important bearing on the main issue in the suit, and the interest of justice clearly renders it imperative that it may be allowed to be permitted on record, such application may be allowed. Full stop. Even, one of the circumstances in which the production of additional evidence under the said provision by the appellate court is to be considered is, whether or not the appellate court requires the additional evidence so as to enable it to pronounce judgment or for any other substantial cause of like nature. Push up. The question which now arises is whether, in case of a conflict between the provisions of clause small a within bracket and small b within bracket, of Order 41, Rule 27 of the Code, comma, the court would lean in favor of one or the other of such clauses. Full stop. Next para. In terms of the proposition laid down in Sanjay Kumar Singh Supra, comma, there cannot be any manner of doubt that even in the event clause small aa is not satisfied by the appellant stroke party which seeks to bring on record the additional evidence, comma, the court, comma, under the umbrella provision of clause small b, comma, may permit such evidence to be adduced, comma, provided, comma, however, comma, that the appellate court requires the additional evidence so as to enable it to pronounce judgment or for any other substantial cause of like nature. Push up hence, comma, the provision of clause, the yardsticks and parameters of clause small b are mandatorily to be satisfied as a sine qua non of overriding the requirement of the appellant stroke person seeking to adduce additional evidence proving due diligence, and that despite due diligence the document in question could not be produced before the trial court. Full sub next para. That apart, comma, we are of the opinion that to ascertain the requirement of the appellate court, comma, which is meant in the relevant provision to be suo motu in nature, comma, the mandatory requirement is that the document, comma, if produced, comma, removes the cloud of doubt over the case and the evidence has a direct and important bearing on the main issue in the suit. Full sub next para. There is no manner of doubt that one of the main issues in the injunction application within bracket, which is to be read within the phrase within double inverted in the suit double inverted close as mentioned in the cited judgment bracket closed, comma, fact remains that the document, comma, even if taken on record, comma, prima facie does not remove the cloud of doubt or has a direct and important bearing on such issue for the reasons given below. Full stop. Next para. On a mere glance of the said document, comma, a photocopy of which is annexed to the Order 41 Rule 27 application, comma, we find that, comma, as rightly pointed out by learned senior counsel for the appellant stroke opposite parties, comma, although the original printed letterhead on which the letter was printed contains the address of WBEIDCL as the suit property, comma, a rubber stamp subsequently put immediately beneath the letterhead in the said document discloses the address of the said entity in Salt Lake. Full stop. Next para. We further find that the seal put on the signature of the author of the said letter also contains the address of the said entity as the Salt Lake address. Full stop. The Salt Lake address is also repeated at the bottom of the letterhead itself. Full stop. Next para. Hence, comma, since a rubber stamp disclosing the sole address of the entity in question to be Salt Lake must have been put on the letterhead subsequent to the date on which it was originally printed, comma, for the purpose of ascertaining the current occupation, comma, it would be the rubber stamp address which is required to be looked into and not the original printed address in the letterhead, comma, since for obvious reasons, comma, the printed address preceded on point of time the rubber stamp which must have been put on the letter subsequently. Full stop. That apart, comma, nothing in the contents of the letter disclose clearly as to whether the alleged subtenant is in occupation of the suit property. Full stop. In the said letter, comma, the said entity merely writes to the concerned college admitting that the alleged subtenant was running a computer center under the said college, which has not, which is not functioning at present, and expressing interest to further continuing the training center at the said college. The mere fact that the original printed letterhead contained the address of the said entity to be the suit property does not per se is not per se relevant to prove that the said entity within bracket alleged subtenant bracket closed is still in possession of the said property. Hence, comma, the document sought to be produced as additional evidence, comma, in our opinion, comma, is not required at all, comma, nor is the same relevant to remove the cloud of doubt over the case in respect of possession of the alleged subtenant at all. Hence, comma, we do not find why the overriding provision of clause small b within bracket of order 41 rule 27 should be invoked to override the incumbent duty of the appellant to satisfy the court as to why, comma, despite due diligence, comma, a similar search as done now, comma, could not be conducted by the applicants at the relevant point of time before the impugned order was passed. Thus, comma, in the absence of the provisions of clause small b of order 41 rule 27 being attracted, comma, the yardsticks as stipulated in clause small a within bracket of order 41 rule 27 have to be invoked. The appellant having failed on the said parameter to prove its due diligence, comma, despite which it could not have conducted a similar research when the matter was pending in the court below, comma, we are not inclined to permit the respondent stroke applicants to adduce such further additional evidence at this stage, comma, when the appeal was already fixed for hearing on the last occasion, but could not be taken up for the purpose of ascertaining whether the facts of the appeal are similar to another appeal which was heard on the said day. In such view of the matter, comma, can 2 of 2025 is dismissed on contest without any order as to cost. The appeal is now taken up for hearing. Yes, what do you want to produce?
Just the written statement.
Written statement was there when the impugned order was passed.
No.
Then we cannot. Similarly,
it actually has nothing new. It only
you have to look into the documents which were there.
No, absolutely. Webel stand that I have handed over possession with its version.
What is the difference? Did you take any written notes of arguments in the last matter?
No,
we did not. By now we have forgotten to so file.
I know, my lord. That is why, my lord, I wanted this matter, my lord, to be disposed of then. My lord, may I do this, my lord? May I prepare notes of argument in both the matters? This matter we didn't argue.
Yes, we closed arguments on the previous matter.
Yes. My lord, may I come with a note for both the matters?
Yes. No, not that.
No, he's right. I was telling
notes. Now with a composite written note.
No, he's right. I was telling him, Dave, that sometimes you remember the basics.
No, if you look at our notes, we'll remember definitely. But what are the differences in fact? I mean,
difference in fact is in this matter, after Milord possession was handed over, a lease was given to Webel and they surrendered the lease and gave back the property.
You can file a composite written notes of argument. Just indicate what is the difference of fact. The other things will be the same.
Yes, absolutely.
And Mr. Dutt, we won't reopen arguments on this, sir.
Yeah, I'll put my. I'll.
Well, he's argued.
No,
Your lordship absolutely argued here to my lord.
No, on the last
on
appeal,
both matters, he's argued.
On the last matter. So, but
Yes, this matter also there was no
we were under the impression initially that the facts were same.
I was under the impression initially.
And we were hearing both of you on both the appeals.
Yes, and thereafter my learned friend next day comes back.
Said that there is a difference in
this
fact
is the
only.
difference. So, and your lordship's view was if I accept your parent argument in that, then in that event this applies to this also. But so far as the subsequent fact is concerned, Millard, I have not made my submission. I get the opportunity to make my submission. But Millard, I need.
How does it make a difference, Mr.
I'll
Dutt?
tell you.
Yes.
my lord, so far as that is concerned, my lord.
Because the other points you have already argued.
Yes, yes. Other points I have argued. Now, my lord,
Take a seat.
my lord,
That may I
You have concluded.
I have concluded. May I have my lord's leave, my lord? I have a fixed matter. I'll come back, my lord.
So that may have it, have the leave.
of course, it's up to you.
Since that was
He is very confident.
no,
No,
he
no.
has some
He
other
won't be
matter.
called upon to answer.
No, not called upon. I'll just go and my lord, I have a 3 o'clock fixed matter. I'll see what is happening and come back immediately in 2 minutes. But my recollection was both sides had closed arguments. I had cited 2 judgments. On that day, they said, I want time to deal with 2 judgments. And on the next day, there were 2 adjournments. And today we are in this situation. For this, my recollection.
But I don't recollect having argued it.
No, Mr. Ratnakar.
I don't recollect having argued it.
Whatever, yes.
But my lord, my argument would be nothing new than what
No.
is there. The only thing is this, my lord, so far as this difference in fact is concerned, whether it has any implication in the appeal or not.
Yes.
Now, my lord, if the reason why my learned friend is harping on the fact that I have been able to establish in this second appeal that I am in possession of the property, basically is to, my lord, contest the injunction on the ground that once I have come in possession of the property and your lease has come to an end by a flux of time, and that I have come in possession from your subtenant. So therefore, effectively, there is an eviction so far as you are concerned. You don't have a right to come back and revisit in this suit, or in other words, come and say that, well, there are any restrictions on me. Now, my lord, to recapitulate 3 things. One is, so far as, my lord, the sequence of lease goes, it is not in dispute that my lease has expired.
Yes.
It is also not in dispute that after expired, that during the continuance of my lease, I had a right to sublet, and that right to sublet has been coming right from the lessor, head lessor. It percolates down, even to my sublessees also. My contention in the other appeal was that A, there, my lord, there is a dispute regarding possession, but be that as it may, on question of law, so far as you are concerned, you are supposed to give back possession to me and to nobody else. And that was the crux of my suit so far as the other appeal is concerned. Similarly, so far as this is concerned, my lord, here also the crux of the matter is that if you have been in possession through me, so long that is there, you cannot turn around and say that I don't have a right in the property and I have actually attorned my rights to a third party. Or I have attorned my rights to somebody who now has a better right. Now, my lord, in this scenario that he claims to be in possession, accept the fact to be correct that he is in possession. Does it factually change the legal position? That is what I'm trying to address, your lordship. My lord, in my respectful submission, it does not. Because of this reason, that so far as the principles of estoppel are concerned, unless my learned friend can show before the court, which is not his case, that there has been an eviction by title paramount, he is estopped from contending. My subtenant is estopped from contending otherwise. And that was my argument in that also. Here, so far as the lessor is concerned, the lessor has not done anything after the expiry of the lease, not even institute a suit, not even give a notice, not even do, but only has executed a lease. The lease that has been given to my learned friend in no uncertain terms says that I am in possession. A. B. The lessor is not bound to give him possession. 2. And 3 is that so far as his right to claim possession does not flow from the lessor. It says in no uncertain terms that this is. So he is a lessee who has taken a lease subject to possession of certain persons. They could be trespassers, they could be continuing, but so far as the lessor is concerned, there is not one single document from him, not one single letter from him, not one assertion from him, and he is not even a party to this. Now, in these circumstances, my lord, If my learned friend is showing before the court that I am in possession of the property through a subtenant, not from the lesser, I didn't get the right of possession from the lesser, but somehow I have managed. That was, I remember Miller, his clear words were, I have not filed anything. I have managed possession from a subtenant. Now, this possession which he has, it is a valid possession in law or not? If to show that it is valid, he has to show that the lesser has indicated that he has a right to take possession, or there has been an eviction by the paramount title. Now, for that, because if this law holds good, Millard, then even if he is in possession, he would probably be bound by the order of injunction. The 2002 SCC. Well, there are two aspects to the matter. One is, Millard, I know Millard, my learned friend will probably jump up, is that there, Millard, the relationship between the parties was governed by the Rajasthan Premises Control Rent Eviction Act 1950. That is the only thing. But so far as that is concerned, the court has not proceeded on the basis that since he is a statutory tenant and all that. I am only on the question of, kindly Millard see.
Proceeded on the general principles of lesser lessee.
What is and when he can claim that I have a right of possession.
All right.
Millard, kindly the first 3 lines of paragraph 1 and then I'll come straight. I'll not waste your lordship's time. The suit property consists of a shop. It forms part of a building owned by Sarvajanik Sampatti Trust, herein after the trust for short. On 1/1/73, the shop was taken on rent by Balkishan. The plaintiff responded on a monthly rent of ₹30. On 25/12/75, Balkishan sublet the shop to Basudev. The defendant appellant on a monthly rent of ₹150. The shop room is governed by the provisions of such and such Act Counsel. The appellant fell into arrears of rent for the period 81 to 31st December 82. The respondent served a notice on the appellant and then filed a suit for recovery of rent, arrears of rent, and also eviction on the ground available under Clause A of subsection 1 of Section 13 of the Act. On March 1983, the trust also filed a suit. Kindly Millard, mark this. The trust also filed a suit for eviction against his own tenant, the respondent, on the ground of unlawful subletting of the premises by the latter. That suit is still pending. In any case, the result thereof is not known. So far as the case before us is concerned, the defendant appellant raised the dispute, putting in issue the rate of rent at which the respondent could recover rent from the appellant, submitting that the agreed rent was in excess of the standard rent and hence was not recoverable. Another plea taken by the defendant appellant was that subsequent to the institution of the suit on March 1983 by the trust against the respondent, the appellant has on 1st April 1983 directly attorned in favor of the trust and entered into a direct tenancy agreement, and therefore with effect from 1st April 1983, the right of the respondent to recover rent and secure eviction of appellant has come to an end. This was, Millard, the issue. On July 83, the learned civil judge Bhinwara passed an order on 13(3) of the Act determining provisionally the rate of rent at which the appellant was required to deposit the rent. This court also, this order dated May, July, it was put in issue before the appellant by filing an appeal in the Court of Additional District Judge Bhinwara. With the order dated 14 May 92, the learned additional judge allowed the appellant set aside the order of the trial court, forming an opinion that in view of the appellant having attorned and entered into a direct tenancy with the trust, the respondent was not entitled to claim rent and recover possession from the appellant, and therefore the suit filed by the respondent could not be treated as a suit for eviction. It remained only a suit for recovery of arrears rents for the period up to March 1980. Respondent preferred civil revision before the Honorable High Court, which was resisted by the appellant, placing reliance on the single bench judgment of Rajasthan High Court with Kevalram versus Bangulal. When the revisional petition came up for hearing before the learned Chief Justice of the High Court, he doubted the correctness of the decision in Kevalram's case and directed the petition to be placed for hearing before the division bench. By order dated August 96, the division bench overruled the single bench decision in Kevalram's case and held that the relations and obligations of the parties were governed by 13 of the Act, and subtenant appellant herein inducted by the tenant could not directly atone in favor of the trust by excluding the principal tenant, and therefore was bound to comply with the order of the trial court under section 33 of that. This was, Millard, the revision, and hence. Now, Millard, kindly come to the portion which I want to rely upon. Paragraph 6 onwards. This would be my argument. I made this argument, I'm trying to, Millard, bolster it. We now proceed to examine whether the appellant could have directly atoned to the owner trust by bypassing the respondent tenant on April 83, relying on the event of institution of suit for eviction by the owner trust against the respondent on March 83, and whether the said event enables successfully raising of a plea of the respondent tenant's eviction by paramount title, bringing the obligation of the appellant subtenant to deliver possession over the tenanted premises to the respondent and to pay rent to him till date. Under section 108 clause Q, which we had relied upon, of the Transfer of Property Act, in the absence of a contract or local usage to the contrary, it is an obligation of the tenant to put his lessor into possession of the property on the termination of the lease. Section 116 of the Evidence Act, which codifies the common law rule of estoppel between landlord and tenant, provides that no tenant of immovable property or person claiming through such tenant shall during the continuance of the tenancy be permitted to deny that the landlord of such tenant had a beginning of the tenancy a title to such immovable property. The rule of estoppel so enacted has three main features. The tenant is estopped from disputing the title of his landlord over the tenanted tenancy premises at the beginning of the tenancy. Such estoppel continues to operate so long as the tenancy continues and unless the tenant had surrendered possession to the land. And 300 section 16 of the Evidence Act is not the whole law estoppel between the landlord and tenant. The principles emerging from 116 can be extended in their application and also suitably adapted to suit the requirement of an individual case. The rule of estoppel, which governs an owner of a immovable property and his tenant, would also apply mutandis to govern a tenant and his subtenant in the relationship. Inter se. As per the Privy Council in such and such, the estoppel continues to operate so long as the tenant has not openly restored possession by surrender to his landlord. That means the lessee. It follows that the rule of estoppel ceases to have applicability once the tenant has been evicted. This obligation to restore possession to his landlord is fulfilled either by actually fulfilling the obligation or by proving his landlord's title having been extinguished by his landlord's eviction by paramount title holder. Eviction by paramount title holder is a good defense, bringing to an end the obligation of the tenant to put the lessor in possession of the property under 108Q of the Transfer of Property Act. The burden of proving eviction by title paramount lies on the party who sets up such defense. What is eviction by title paramount in such and such with such and such? Martin J. speaking for the division bench and on the review of the judicial opinion stated the law in the following terms. To constitute eviction by title paramount, no physical dispossession is necessary. If the true owner is armed with the legal process for eviction, that means which cannot be lawfully resisted, even though the tenant not put out of possession, the threat to put him out of possession followed by atonement amounts in law to eviction. Similar, the action has to come from the true owner, the landlord. If in such circumstances the tenant openly and to the knowledge of his landlord atones to the true owner, the estoppel is gone. The atonement, however, must be under compulsion. The party evicting must have a good and present title and the tenant must have acquitted against his will. It is further held in such and such that there is all the difference between mere voluntary atonement and atonement under compulsion. A mere voluntary atonement would not enable the tenant pleading eviction by title paramount, nor will the mere institution of a suit against the landlord by the true owner be enough. An unexecuted decree for possession obtained by a third party does not per se operate as an eviction of tenant by title paramount, liberating him from the estoppel against the pleading justly. The decision was followed by Justice Vivian Bose in Purushottam Isdar versus such and such. If A lets land to B and B enters into possession under the lease, B is bound to return possession to A on expiry of the lease, and he will not be allowed to set up the right or title of a third party C. If A directs B to surrender possession to C, that might be a different matter. But here there is no direct communication between A and B. What happened was that A told C that C could enter into possession when the lease expired, but before that happened, A changed his mind and demanded possession from the lessee. In these facts, it was held that once A demanded possession from B, then B cannot be heard to say in answer to that demand that C has right against A. A was held entitled to decree for possession against B. Well, this fact is somewhat similar to ours. A decision of Madhya Pradesh High Court in Radhelal versus Ratan Singh bears a close resemblance with the facts of the case at hand. The suit premises was owned by municipality on 21st November 60 taken on rent by the plaintiff. They were let out by the plaintiff to the defendant. On 63, the plaintiff determined the tenancy of the defendant and demanded areas of rent as also possession. On the defendant's failure, the plaintiff filed a suit. The defendant, while admitting that the suit was initially let out to him by the plaintiff, inter alia contended that the rules of municipality prohibited subletting of the premises, and as a dispute was going on between the plaintiff and the municipality, the defendant had applied to the municipality for grant of a lease to him of the suit premises, which was agreed to, and since the year 1962, the defendant has become a tenant of the municipality. Referring to 108Q of the Transfer of Property Act, the Madhya Pradesh High Court held that the obligation of the tenant to hand over possession to the landlord on determination of tenancy cannot be escaped by the tenant contending that he has entered into a contract of tenancy with a person who has paramount title over his landlord, and by voluntarily entering into a contract with a person from whom his lessor has been holding the lease. The landlord's tenancy had come to an end by operation of law, and therefore, in the opinion of Madhya Pradesh High Court, the subtenants voluntarily becoming the tenant of the municipality, and that too without the consent of the plaintiff, that is his own landlord, cannot be set up as a defense for discharging his obligation under 100Q of the Transfer of Property Act. Yet another reason on account of which the defendant was held not entitled to save his possession on the basis of his having allegedly become a tenant of the municipality was that such transaction had taken place during the pendency of the suit between his landlord and himself, and therefore it was hit by the provisions of 52 of the Act. Defending actual possession held bound to deliver possession to the plaintiff. In Gadadhar Lodha versus such and such, the following statement of FOA's general law of landlord and tenant has been quoted with approval by the division bench. Eviction by title paramount means an eviction due to the fact that the lessor had no title to grant the term, and a paramount title is the title paramount to the lessor, which destroys the effect of the grant with the corresponding liability for payment of rent, so that mere eviction from or a deprivation of use of enjoyment of the demised premises or part of them, whether such eviction be lawful or unlawful, is insufficient where the lessor's title is not affected or called in question. To constitute a good defense of eviction by title paramount, three conditions must be fulfilled. One, the eviction must have been from something actually forming part of the demised premises. The party evicting must have a good title superior to that of the lessor and that of the lessee. Three, he does not fulfill. The tenant must have quitted against his will. In so much as so, then, my lord, in such and such it has been held that even if not actually evicted, if the judgment is passed against the tenant, he can repudiate the title of his immediate landlord. But the mere fact of an apprehension that a suit for apprehension that a suit for eviction might be brought to the paramount landlord does not justify denial of title of landlord and adjournment to paramount landlord. We find ourselves in agreement with the aforesaid judicial opinion, and to sum up, we say as follows. To constitute eviction by title paramount so as to discharge the obligation of a tenant to put his lessor into possession of the leased premises, three conditions must be satisfied. The party evicting must have a good and present title to the property. The tenant must have quitted or directly attorned to the paramount title holder against his will. And either the landlord must be willing or be consenting party to such direct attornment by his tenant to the paramount title holder, or there must be an event such as a change of law or passing of a decree by competent court, which will dispense with the need of consenting or willingness on the part of the landlord, and so to bind him as would enable the tenant handing over possession, attorney in favor of the paramount title holder directly. Or in other words, the paramount title holder must be armed with such legal process for eviction as cannot be lawfully resisted. The burden of raising such plea substantially received will be clear. So, my lord, even if your lordship accepts the factual situation to be correct, my lord, 108Q still governs the field. And my learned friend has not, in the written statement which he was trying to, my lord, show, also does not say that, I'm sure, my lord, I have seen the written statement, there the Webber does not say that he fulfills any one of the three conditions. And my learned friend, the case is also not that. So therefore, I reiterate my submission that any step that can be taken is by the parent landlord. And the only step the parent landlord has taken has assigned his right to rent to him. That was my submission, that if you read the lease, he is a lessee without possession. So, Millard, in surreptitious way, if he comes into possession, except for the time being he is in possession, the order of injunction, Millard, also restricts him from creating third-party interest because he has come into the possession wrongfully. So it makes no difference in law, in my respectful submission, subject to Millard, what falls from my lord. That. Oh, Millard, my learned friend cited a judgment. Possession গন্ডগোল ছিল
Acquisition করেছিল state, সেজন্য ওর right to reclaim possession had to এখানে
টাইটেল
হ্যাঁ ও টাইটেলই চলে গেছিল to reclaim possession. That's the difference.
My lord, one judgment my learned friend had cited, which is 2001 volume 6 SCC 512. It's on the land requisition and acquisition. My lord, kindly permit my, he is ready with that.
No, Ricky. My lord, if your lordship sees the
My lord, those have been my submissions in both the appeals, my lord. Deeply obliged.
this one,
May I take your lordship? The matter is well.
my lord, if your lordship sees here, kindly have a look at paragraph 31, on which
Yes.
my lord, my learned friend has problem. A person whose lease has expired is still entitled to maintain possessory rights so long as and until he be evicted by due process of law. There is no problem with respect to me. The next lines, my lord, I'm sure he's relying upon. However, the factual aspect of the matter has to be gone into to make the provisions of law or judicial precedents applicable. The proposition which is noticed above pertains to the possessory right and eviction in accordance with law. In the present case, the lessee has lost his possessory and the same stands shifted onto the state because, my lord, there was a requisition by the state. So today, my lord, the person who was in possession didn't have a right to get back into possession. And that's the massive difference, my lord, between our case and the case cited by my learned friend. So if I had a right to remain in possession, then, my lord, I would something, my lord, X and Y, Z says I'm getting into Y, X you go get out. This is the difference. And what Mr. Doctor had, my lord, submitted before your lordship, surreptitious,
Well, I'm not going to repeat that. That's already there before. So this is the basic difference, my lord, in our fact and that.
Yes.
Firstly, my lord, this judgment 2002 volume 2 SCC page 50. Three reasons, my lord, why it will not have any bearing on the present matter in my humble submission. Number one, my lord, is it is subtenant. I'm sorry, my lord, a tenant who has no subsisting right, who retains no subsisting right in respect of, my lord, a property, cannot claim the benefit of, my lord, opposing eviction by title paramount. That's, my lord, the first, my lord, limb of my submission. Now there's A, B, and C. My lord, A gets possession from C. B, my lord, cannot oppose eviction by title paramount unless, my lord, B has some subsisting rights in the property. And that, my lord, is the equity in the situation. If B is a trespasser, B cannot invoke this position. Otherwise, the law would be that a trespasser is entitled to, my lord, get back possession from a true owner, which can never be the law, my lord. And that's why I cited, my lord, the Mongolahat matter, where, my lord, if your lordship sees the Mongolahat matter, my lord, 2001, volume 6, SCC 512.
Yes.
That from, we had read, my lord, paragraph 16. The lessee has ceased to be a lessee by reason of the expiry of the lease by lapse of time. What then would be his status? Does the lessee continue to be in lawful possession of the leasehold property, assuming there was no requisition of the premises, or alternatively, is he a trespasser? And if so, can he be removed from the premises excepting by due process of law? The other question which also arises is, namely, can the lessee of an expired lease without a renewal clause be termed to be a tenant holding over? Then, my lord, I will, we've read it before, so I will not read it in great detail. The paragraph 24, my lord, is trespass and the whole discussion. Then, my lord, paragraph 31. If you're in settled possession, my lord, you're entitled to protect, even if you're a trespasser. But having given it to your subtenant, you cannot say that I am in settled possession. Now, that's what paragraph 31 says. Here it was, my lord, because of acquisition-requisition proceeding. But the principle is the same. You're not in settled possession. So what do you have? You don't have actual settled physical possession, nor do you have title. So therefore, this principle cannot, my lord, apply to you. Now, my lord, to come back to distinguish the judgment, please see, my lord, paragraph 4, which Mr. Dutt, my lord, cited today. So, Dr. Sai, where, my lord? I corrected
Our hunches were vindicated. Mr. Chatterjee referred to him as Mr. Dutt.
No, he refers to himself as Mr. Dutt sometimes.
That is what we asked also. What does he refer to himself as? Depending on Because I have seen both sides.
Yes.
That's why I am in a position to ask these questions. And anyway, paragraph 4, yes.
Paragraph 4 at page 56. Yes.
No, at page 56. Yes, let us come back to page 56.
Placetam A.
Yes.
Secondly, in spite of the tenancy having come to an end under the provisions of the Transfer of Property Act or by the terms of a tenant does not cease to be a tenant and continues to hold that status unless and until a decree for eviction under provisions of this act has been passed against him. That's not Rent Control Act situation. In a Rent Control Act situation matter, it would be different because, my lord, tenant after expiry of whatever, after termination continues to be a tenant until decree for eviction is passed. But in a Transfer of Property Act situation, you're a trespasser. Now that's been not clarified. Where tenancy premises are governed by rent control law, merely on termination of tenancy, the tenant cannot be evicted. Tenant is entitled to continue in possession, enjoying status almost on a par with a person whose contractual tenancy subsists. This is not the distinction. Same position will not. Paragraph 5 at the bottom, respondent tenant holding the premises from the trust would remain a tenant until passing of a decree for eviction on one of the grounds contemplated under section 13 of the Act in a suit filed by the trust. In spite of a threat for eviction, it says respondent neither liable to be evicted.
No, we said Dr. highlighted two things. One is that there is no threat for eviction from the paramount title holder. One. Secondly, the surrender was voluntary, not forcible. But those are two of the.
It's not voluntary. This whole concept, comes out of the principle of estoppel. That you have obtained your right in respect of a property from somebody, you're stopped from disputing that. But when that person himself loses the right, it doesn't apply. I'll read the relevant portion. It's there in this judgment itself.
One important component is that the estoppel operates to the title of the landlord at the beginning of the tenancy.
Yes.
But in Karim Bhai, it has been, we are reading para 6 of that judgment.
Yes.
The end of it, which Mr. Datta placed. In Karim Bhai, it was held that the estoppel continues to operate so long as the tenant has not openly restored possession by surrender to his landlord. And it continues to say that that surrender cannot be voluntary. Now, there can be two ways of interpreting this, which, I mean, both of you will be. One is that this estoppel continues to operate so long as the tenant has not openly restored. This estoppel operates to estoppel from disputing the title at the beginning of the tenancy. That remains.
Yes, because that's when he had the title.
Yes.
Then when he loses the title, it doesn't continue.
Nobody is disputing the title of the landlord at the beginning of the tenancy, but you say subsequently it has happened.
Yes.
Another way of looking at this is that estoppel, landlord-tenant estoppel itself continues till that principle embodied in section 116 has been elongated, extended to the point of time till it is restored. And till that date, he cannot dispute the title of the landlord.
So he can never is the answer.
Till he surrenders. He can never till he is in occupation.
He can never. He has to hand back to a person who has absolutely zero right in respect of the property, who then will continue to assume settled possession.
Intersay the subtenant and the tenant. He cannot.
He can.
As far as he is concerned, he has to surrender to his tenant. That is the proposition advanced by Mr.
Advanced by Mr.
He has to surrender to his tenant, whether he has become a trespasser or whatever. Subtenant cannot be concerned with that.
Irrespective, what Mr. Datta's argument is, irrespective of status of tenant, subtenant has to hand back possession to tenant.
Yes.
This long and short is this.
Yes.
Now, number one, I'll just give the bullet points why this
Because
is.
here the subtenant has directly handed over to you. He says that cannot be done.
Cannot happen.
Insofar
So-
vis-a-vis his landlord.
I have given you, you have to
return
give back to me.
Yes.
Then I'll do what I want. Now, my lord, number one, this doesn't come up for consideration. This academic question is rendered an academic question because he has not, because of the reliefs claimed in the plaint. He has not sought to recover possession from me. So therefore, there's Lordship will see the plaint praise. On the I took great pains on the first day. This was I laid great stress on that. It's been some time. So the infructuous exercise. I'm assuming what Mr. Dotto is saying is right. In that case, possession is wrongfully handed over to me. If it is wrongfully handed over to me, then I am obliged, the court will direct me to hand back possession to my lord, the tenant. But your lordship would see that the decree for eviction in prayer A of the plaint, my lord, is against Webel or WBEIDCL. Page 63 of the plaint is the prayer of the petition is the prayer in the plaint, and the plaint starts at 48, which is why I said it's a incurably defective suit. Secondly, despite the fact of handing over of possession by subtenant to tenant being in his knowledge, neither has he challenged it, nor has he sought a declaration. And there's no relief apropos the handing over of possession. So therefore, the whole issue need not be considered. That's, my lord, the first part of my submission. Second part of my submission is that if your lordship first, my lord, looks at the judgment which I cited, my lord, 2001 6 SCC, it prevents, my lord, it says that anybody who's not in possession, I'm sorry, my lord, anybody who has no right in respect of a property cannot, my lord, get back possession of the property, that too from the true owner. So this is something you can't get. Once, my lord, I have taken back possession. Now this, my lord, is still good law. There is no change to this branch of the law.
Yet the plaintiff had given possession to that WB.
Yes. He had given possession to the WB electronic something.
He says that WB Electronics has to give it back to him.
Yes. He says,
Cannot give it to a third party.
Cannot give it to you. And in the first case, he says that no, WB is still in possession, despite the entire evidence on record. In the second case, he says, no, very well, if possession has been given back, you couldn't have taken it. So, lessee whose lease expires by efflux of time cannot claim to be put back in possession. Because lessee who, this is not rent control legislation where your right remains. Here you are a trespasser. So then the law would be that trespasser can, my lord, get back possession. Get possession from the true owner. That's, my lord, a difficult
Not from
situation.
the true owner here.
Or not here, but somebody who
whoever.
has title. So true title. That's number two. Now, my lord.
Trespasser is the bottom of the rung.
Bottom of the rung.
So he cannot also claim better title.
And who can't get any support from law.
Cannot be worse than a trespasser. I mean, therefore, he cannot claim a better title. Even a better title person can claim eviction against a worse title person.
Yes.
But
Worst title
Dispersal
cannot
is the
get worst.
the bottom of the rung.
Nobody worse than you.
And they cannot also claim better title after expiry of that.
Yes.
So they cannot claim to be a tenant nor a better title.
Not better title. Now, my lord, very interestingly, your only thing which a trespasser has is right to remain in settled possession
Without due process of law.
without due process of law, which is really to be protected by the police authorities, etc. But
Here they
that's
don't claim
that's
injunction.
not the thing. Which, my lord, when you're actually, my lord, it goes out from, my lord, the tenant to the paramount title holder, my lord. At the end of the matter, nothing remains. And your lordship will see paragraph 13 of this judgment. The estoppel has been explained in the last second penultimate paragraph.
Which one? Keval Chand.
Vasudev. Keval Chand Bhimani is the one which I had cited.
Yes, the paragraph. Which paragraph of Vasudev?
Vasudev, my lord, paragraph 13 at page 60.
Yes.
My lord, kindly see, my lord, at page 61, last page of the judgment.
Yes.
This court third line, this court stated that the rule of estoppel and set out the well-settled exceptions to which the general rule of estoppel between landlord and tenant is subject. Firstly, tenant is not precluded from denying the derivative title of the persons claiming through the landlord. Secondly, estoppel is restricted.
Second one is German.
Yes, estoppel is restricted to the denial of the title at the commencement of the tenancy. That is, it is open to the tenant, even without surrendering possession, to show that since the date of the tenancy, the title of the landlord came to an end.
That was the first interpretation we were saying about para 6. Because
Or that
116 is restricted to the beginning of the tenancy.
Yes. Or that he was evicted by paramount title holder. So, my lord, it's, my lord, there are two, my lord, defenses. One is two defenses of subtenant. A, I've been evicted by paramount title holder. B, I am, my lord, disputing your title. Two things. Estoppel, my lord, subtenant has two ways out. Mr. Dutt was only mentioning about the first way, eviction by paramount title. Second way is subtenant of a tenant who has no right in the property has the liberty, and estoppel doesn't bind him to oppose tenant's title. Which is why otherwise, my lord, this is very logical. Otherwise, my lord, your lordship would see there would be mayhem. Subtenant.
So the claim that the title of the landlord came to an end is one of those solutions.
Yes.
As per
can,
this.
yes, as per his judgment. You know, I was wondering if this law, my lord, is the correct, my lord, if it's an absolute correct, of course it's correct. But if it's an absolute proposition, then what will happen? Tenant will have to, subtenant will have to give back possession to tenant who has no right. And then then landlord will have to, landlord will have to hand back and then file a suit and take back. It will not sound, first principles, it sounded difficult. No, this is the reason. So this estoppel dissolves when, my lord, tenant loses rights if the tenancy is under Transfer of Property Act.
All right. Done.
We have also exchanged, my lord, unpleasant
Hear
statement.
more. Lordship wanted to hear more. I
So,
don't know, my lord,
two-page
whether
note.
I have a
My lord, but
there's no right to reply.
I will
But the law which
this.
he stated, my lord, is quite
Transfer of Property Act.
We'll think about that. Yes.
Yes, kindly consider. My lord, I'll make a two-page note and give it tomorrow, my lord.
Tomorrow, can you?
Amadev?
You'll also be able. Very well. So
Or-
tomorrow we'll
origin side.
No,
You know?
this is, if I have to make a comment, I'm being compelled to make a comment now that in general, the people who practice in the original side, they are much more efficient than people who practice in the appellate side, in the side in which I practice, in general. That may be because of various reasons. This is absolutely, I mean, a politically incorrect statement, if I may say so.
No, not politically.
but the line,
But because
Lordship putting it on my side.
no,
on
because
Lordship
because,
side, but-
because we're telling maybe because of different reasons, because the original side bar is smaller, more compact. Maybe one of the
Court
reasons
bar is the smallest.
so many people come in the appellate side. That may be one of the reasons. But I generally see, I've found out from both sides.
Appellate side again.
That's why I mean, although I practice almost, I did not practice in the original side at all. But after coming this side, I'm finding out that original side people come much more thorough from the junior to the middle rank. Seniors, same both sides.
Your Milord, the problem.
Juniors are very good in the appellate side. Also, middle rank is very good in the appellate side. Juniors are also very good. But sometimes we find that appellate side when we come. I also used to come less prepared. Must be come a bit less prepared than the original side people in general. Mr. Chatterjee, I don't know the reason for that. This is not a general statement. Many people come very well prepared in the appellate side. Some people don't come very, but the ratio is much better in the original side. I don't know why.
Because appellate side again, Milord, is divided. Appellate side is not, Milord, there is a civil code.
Maybe due to
appellate side.
various reasons.
There is no reason.
But I honestly
There is
now
no-
feel, my lord, that the
Because I have
divide.
found that out generally after coming this
Your
side.
Lordship made this comment the moment your Lordship sat in this determination.
Yes, I don't mince words about that, Mr. Chatterjee, and I
Absolutely.
want the appellate side people to come more prepared,
Absolutely, Milord.
to be better. In
This-
general, I'm telling.
But this
Some people are very good in the appellate side. Some people are not so good in the original side.
individual.
Yes, it's individual.
But overall, I find.
But it's not about appellate and original. It's
To
subject to
spend
Lordship.
one day this side and in the appellate side and original side, you'll know, Mr. Chatterjee. I can't explain that to you. I mean, from that side, it will be very difficult to appreciate.
I'll tell you, Lordship,
Because we are
why.
taking up several
I can-
matters.
I can say why, and it will also be politically incorrect. The people who were the senior most in the appellate side, they did not groom, Milord, the next generation well.
That may be one of the reasons.
Did not.
That may be one of the
And
reasons.
I have told that to
Maybe
them
one of the-
directly.
It may be one of the reasons. Yes.
In my respectful submission, Milord, that is probably the only reason.
And the percep.
Then it is still
That-
there
that-
with
that-
the original side, Milord,
That may be one.
that they attend chambers. A person who comes to practice, Milord, in the original side will go to a senior. And
of
a
course.
senior will look after. Today, Milord, if you comes to this side, first day I'm alone. So that basic training, Milord, which I feel is not coming in.
Maybe a very major reason.
Major reason. Major reason.
But from our side, my lord, we, at least my generation, we feel that the.
Your generation is equally, I mean, we are very comfortable with your generation.
Yes, but we feel that the divide
No,
is not
Our
there.
generation,
Your
Milord,
generation means
had a
years up and down also.
understand,
I mean,
we had, Milord,
range is there,
a senior.
downwards.
We had that chamber
That may be true.
practice.
Yes.
We had the chamber practice.
Your generation downwards, I mean, we are very comfortable because we don't feel, I mean, any difficulty in expressing our minds. Just because we express our minds, that does not mean automatically you will start another day's argument.
No.
Not that. Very rational. I find rationality in the.
No, it's because of this. We are losing chamber practice this side. And this is very, very wrong.
But you people have to take care of that. You are now in charge. People like you, not you alone.
No.
Several
I
people.
understand.
Even
But
people.
I have.
Mr. Kormakar was your junior, but he's pretty senior now also. I mean, your generation I'm speaking about.
No, they
You should
have
take charge
so
of
many
that.
juniors will under them. There is no problem at all. All of them, whoever your lordship thinks
No,
about.
this is a very general statement that does not apply. I mean, it cannot be general on this.
That's why I said.
But generally, suppose when I was taking up I'm being very specific, the arbitration and those matters. I mean, people from both the appellate side and original side come there. Mostly original side people, but I found it much easier to, I mean, people more rational in a sense.
Today, what happens?
I don't know
is
why.
What they are, Lord,
Maybe a
better at,
reverse bias acting,
what
maybe.
they are, no, not reverse bias. It is true because what they are, Lord, good at is knowing the facts very well.
No, there is no they in the,
No,
us
I'm
now,
saying
because
original.
all are practicing in all sides nowadays.
It
is only because he does civil lord practice. That is why your lordship is feeling this way.
That is correct.
Anyway, so
I
we'll
can
keep it
answer that
tomorrow.
with a lot of things.
No,
but
no,
your
no,
lordship will
somewhere
have a
else, some place else.
Some place else, Lord.
Some other time, some other
Some place else, Lord, nowadays.
Some places now nobody goes. At least my
Nobody goes
generation doesn't go.
No,
That was our
much better place.
On Thursday.
Demanding something.
He's asking you, he's telling me, are you sure you will do it this evening? I said, yes, I will.
Poor Mr. Bhattacharya.
No, I will do it.
He'll
And I will
be at
file
the
it.
receiving end of the flag.
No, I will do it myself and I will file it.
Whatever you
Could be
say.
not.
Thursday. Day after tomorrow?
Yeah, after
Thursday. Very good, Thursday. Heard learned counsel, hearing is concluded. Push up. Oral arguments are concluded. Stop. Learned counsel for the parties are requested to file their brief written notes of arguments on May 1, 2025, when the matter shall be placed in the list under the heading to be mentioned. For such purpose.
Matters together, my lord,
We'll take, yes. File composite notes of arguments. We'll do something because we have concluded arguments earlier. We have kept that on hold because of this matter. So we may pass judgments together also, and because otherwise we'll be guilty of copy paste of most of the judgment.
Singapore High
Singapore,
Court.
yes. I was a part of a division bench. We did the same thing. People have forgotten that, luckily.
He copy paste.
Yeah, I was the junior member of that. After a few days after coming this side.
I have
Coming
found
to this court only.
This court, from a learned single judge of this court, a matter came up before the division bench, which was presided over by my learned senior partner.
I know. At
Caustic
that
comments
time.
were made. I diluted the comments. I took one day. I requested my usual, but
Section 34 matter. I know.
yes. So let us forget.
I have lost a matter.
This has become, my lord, because it was international.
Yes, exactly. And because he was a
Former
Chief Justice of
CJI,
India. That's why.
CJI.
That's why.
I've got a judgment of a learned single judge of this court. Without entire
Not one,
decision.
Mr. Chaudhary, not one.
Copy paste from an article.
Hey, lordships are writing judgments.
1 month back.
Pink Floyd. So it's
No, that's
Pink
fine.
Floyd is fine.
That's a
I
fine
love
thing.
modern judgments.
It's fine.
Yes, that's a
I use
fine
Avatar
thing.
and all these things.
So,
Why shouldn't we?
So Pink Floyd,
As
my lord,
long
isn't
as
that modern.
Pink Floyd, no, not modern. The usage is modern.
Yes.
Pink Floyd coming into. Why shouldn't we do
Gujarat
that?
High Court, I just read it a few days back. He started off with.
I've seen that.
Quoting.
No, I
appreciate it.
use phrases like it's a no and all these things. I mean, why should, unless it's unparliamentary, we should be modern in our approach.
Yes.
Otherwise, we'll continue going with herein before and therein after and.
No, that is perfectly all right. So because law has to evolve.
Yes,
Society has
the
to
language also, so that the litigant can understand the logic of the law.
As simple as possible.
So let us come back on Thursday. Thank you very much. Yes.
Item number 39.
Contempt.
Yes,
Appellant petition on this matter.
appears for the respondent, my lord. My lord, now, my lord, the contempt and the applications have come together, my lord. Now, Mr. Bhattacharya, my lord, is the advocate on record, my lord. There has been a bereavement in his family in the morning, my lord.
In this morning?
This morning, my lord.
Lord,
Only and not today, my lord.
I cannot, Lord, in such a situation, I
But-
cannot say anything. Lord, only one thing, Lord, if they can in the meantime exchange their affidavits, Lord, so that we can.
Affidavit on
In the
what?
contempt application?
Contempt.
That will be entertaining the contempt. No,
My lord, keep
affidavit
the
were
matter
directed.
tomorrow. My lord, keep the matter tomorrow, my lord.
No, affidavits
Lord, against contempt,
were
Lord, they
filed.
have not filed.
Oh, that was against the
In the
Other
CAN
one.
applications, my lord.
contempt. Let us come back tomorrow, Mr. Karmaka. If you are prima facie satisfied, there is no contempt, then there is no scope of that. On the prayer of the alleged contempt,
The respondent in the appeal as well, my lord.
on the prayer of the alleged contemner, within bracket respondent in the appeal, comma, the matter is adjourned for the day. Be careful not to give the name of Mr. Bhattacharya.
Definitely
Yes.
not, my lord.
Mr. Kormakar, your names, please.
Yes,
Ask somebody.
For the petitioner.
Yes.
I'll sub note and may I file affidavit of service note.
Yes.
Below
You have a-
lordship.
The usual
on-
culprit. Bank must.
No,
Not bank. Thank God. Yes.
Lordships on 26 November 2024.
Why two affidavits of service? Two contempts.
No, Lord, one but copies. Lord, since division based, Lord, copies there. This is
Oh,
like-
acha. Oh, all right.
Lordship.
Affidavit of service.
Lord, on 26 November 2024, my lord, granted visitation right to mother who is appellant, my lord. That, my lord, girl child who is presently, my lord, 12 years old, she will be brought to Gitanjali Kanan at Bahla.
Yes.
On every
They're
Saturday.
not doing it.
Yes, they, my lord, on 15th March, 22nd March, and, my lord, 29th March. They did not bring, my lord, in the court, my lord, on 24th March. It was informed that she was taken to Bombay by father, and, my lord, mother has given consent. Though, my lord, in the in paragraph, my lord, I have stated that no such consent was given by mother. That is why this petition is taken out, my lord.
Yes. What is your stand on this?
Lordship, subsequent to receive this contempt notice, I have talked with my client. The Lordship, subsequent to passing of the order of visitation rights, the husband has not made any default because he is posted in Bombay. He has not flouted the order of the Honorable Court. The child were continuously on every Saturday met with his mother.
He's giving 3 dates.
Yes, 2 dates.
3 weeks.
Then subsequently what happened? Your Lordship, the examination of the daughter, 10 years daughter.
Why didn't you inform the
Lordship,
mother?
The mother had a talk, the daughter had a talk with the mother. And the mother was trying to get her confidence. She expressed her desire that during vacation she intend to visit father in Bombay. So she has consented very well to impress upon the daughter that she is given her consent. On that good gesture, she left to Bombay. And once again, thereafter, two dates she defaulted with the consent of the mother. Now she is filing this application before your lordship. She has not consented. But the fact remains, if so required, your lordship, I can bring the daughter before the court. I being an officer of the court, I also charge my client, you ought to have taken permission from the court. But the husband, the respondent before your lordship is saying that the daughter was so confident that the mother will not going into control anything. On that bona fide impression, I took her to the Bombay only during vacation period. After that,
coming
she's
back.
continuous.
She has come back.
Yes,
After that,
continuously. She's continuously meeting. Even last Saturday, she go. But
yes, Mr. Jaiswal, then why
Also,
this
one thing,
There's
most humbly, my lord, could I submit
application regarding a girl? I mean,
my lord, most humbly could I submit, but he has also, my lord, assented, my lord, that since point involved in this appeal, paper books have been filed, my lord, very small, my lord. That
yes,
learned,
the appeal be heard.
may lordship kindly heard it, my lord. My lord, trial court proceeded on the basis, my lord, a child who was 10 years old at that time, my lord, she expressed her desire that she will continue with father.
the paper books are ready.
Yes, my lord, paper books are ready. This point and another point, my lord, that the mother approached before the civil judge, my lord, in 2022, while she was expelled in 2018. But that is perverse order, my lord, for
Then
perverse
what do we
fighting.
do with the contempt? Contempt is an independent procedure.
Yes, my lord, may kindly dispose this, my lord, and my lord, kindly fix the date, my lord, so that appeal may be had. Very short point, my lord.
Do you
involved
agree
there.
that you gave an impression to the child that
No, mother is here, my lord. Mother is here.
no, I
talked-
don't want to.
No, my lord, I talked her. No,
The mother is here, the daughter will be here.
Mother is also here. 12-year is also here. Probably.
Yes.
My lord,
So let us not pit them against each other in
Yes.
court.
my lord,
I'm not even looking at them because that will attract gazes of people. Why?
Lord, my lord, kindly fix a very short points are involved. My lord. Paper books have been filed, my lord.
অ্যাপিলটা দিয়ে দিই বাচ্চার ব্যাপার কন্টেম্পটা কি করবো in the contempt will direct you to file affidavits
Let's
and
say
will
because the
direct you to
husband, let's say husband is in Bombay.
Oh.
Let's say can he dispose of the application because there is no continuously daughter is meeting. Only 2 dates. She's
Well, we'll
continuously meeting.
put it somewhere in between. Affidavits of service filed today be kept on record. Full of learned counsel appearing for the alleged contemnor submits that on the basis of the impression given by the appellant mother to the child, comma, who is 12 years old, comma, that she would have that the petitioner mother would not have any objection if the child went to Mumbai to see her father, comma, the child was taken to Mumbai to his father, the alleged to her father, the alleged contender. Full stop. It is pointed out that barring 2 or 3 occasions, comma, the visitation rights have been honored, are being honored by the child being taken to the designated place of visitation, and the petitioner mother has also been having such visitation of the child even after such dates on which the child was not taken to the place. For the next para, learned counsel for the petitioner submits that in view of the disputed position of fact, comma, instead of delving into the question of contempt, comma, for the ends of justice, the appeal itself be taken up for hearing. Full stop. In view of the fact that whatever might have happened in between, comma, it would be difficult to decide or attribute faults to either of the parties, comma, since it will boil down to averments made on oath versus oath. Full stop. Even otherwise, comma, since the alleged contender has since been affording the visitation rights to the petitioner mother after the 2 or 3 dates on which such visitation did not happen, comma, we are loath to keep the contempt application pending unnecessarily. Full stop. Accordingly, CPAN 538 of 2025 is disposed of in the light of the above observations. Full stop. Next para. On the prayer of both parties, comma, since it is submitted that paper books have already been filed, comma, the appeal be listed for hearing. It's an FAT.
Lordship.
Against divorce decree.
Against the
No,
refusal for
section
custody.
47, my lord, under Guardians and Bond Act. My lord, why application?
Would have been an FMAT then.
My lord,
Yes, just.
Why is it an FAT?
my lord, since no defects were pointed out earlier, my lord, I filed section 25 application under
Paper books
Guardian
were
and Bond
directed
Act.
to be filed.
Yes, filed, my lord.
We directed.
Lordship.
When?
My lord, in December, this order was made, my lord, modified, my lord. And in January, my lord, I filed.
And paper books are admission, formal admission. কি বললাম লাস্ট তন্ময়? শেষটা কি যেন? Next para. We find from the previous orders passed in connection with the appeal, comma, that the appeal had been taken up for hearing on several occasions and interim orders had been passed previously. Full stop. As such, comma, we deem that the appeal stands admitted. Full stop. Next para. Since a miscellaneous appeal is required to be preferred against an order of the nature as impugned herein, comma, we direct the appeal to be reclassified as a first miscellaneous appeal and an FMAT number be allotted accordingly by the office. Such exercise shall be concluded within a week from date. Next para. The appeal be listed for hearing on May 8, 2025 under the appropriate heading. এটা ডিপার্টমেন্টে পাঠিয়ে দেবেন, রিক্লাসিফাই করে দেবে, রিনাম্বার করে দেবে।
মে আই প্লে ওয়ান থিং
করে ওই 8th মেতে বৃহস্পতিবার যেদিন অ্যাপিল হিয়ারিং নি সেদিন হিয়ারিং এ দিয়ে দেবেন।
But could it at the Lord such position that it may be taken?
No. We are not adding any appeal because it relates to a child. We are just adding it in the list.
Lord, here, my lord, the grandparents are above 80 years old, my lord.
We understand there are many other
my lord,
people
he
also
is at the
waiting in the
mercy of
queue.
God,
We
my
cannot
lord.
jump the queue. Sorry, no. We are adding it in the list because this relates to a child and the custody of a child, only because of that. Because otherwise we cannot jump the queue. We have been refusing since the last few weeks inclusion of appeals.
Good, sir.
Thank you. Yes, Mr. Pal, what is the matter? Oh, Mr. Raut is there? Yes. Yes, Mr. Raut. Some things were not filed. I mean,
subsequently that has been regularized, I think. Regularized.
certificate copies have been filed.
My lord.
That was lying in the report.
Always there. Achha.
The stand reporter endorsement is also there.
Oh, very good. Other defects still awaits rectification বলছে।
When the left hand side will be checked after reports, when the left hand side will the defects, the right hand side will
The rejectment suit number is wrong in the PM.
the C, my lord.
Yes, sir, state office.
Ejectment suit number is 82 of 2003.
Correct, yes. Title level 79.
2003-C.
C.
Because at that point, Lordship, the new
Computer.
new act, it was a descriptive. Two courts were designated with the as a civil judge. One was the third judge, and the other was the fourth judge of citizen.
I think C indicates third judge, third bench.
E indicates at that point of time the fourth judge.
All right, now it's informed. So let us hear it, please. Order for time.
Well, first of all, your lordship kindly take up the next matter, appearing as item 42. That is the main appeal.
What is the appeal number?
Appeal number, first appeal number is my lord, number.
SA 59 or what?
59. My lord, this is against the judgment.
Why two appeals?
Because of the fact at the time of passing of the decree by the appellate court, suit for eviction failed, dismissed. Thereafter, they preferred the appeal.
Their suit for eviction failed, preferred appeal, that was allowed.
First appellate court allowed the appeal. But in the operative part of the judgment,
yes,
the judgment data defendant was directed to quit and vacate the portion, which is not the subject matter of the suit. What happened in this case? Schedule of the property, what was given in the plane, that was not reflected in the body of the decree.
Body of the
decree, appellate decree. What happened in this case?
Different property. They were directed to be evicted from a different property.
Different property.
So that's why they
they could not put the decree into execution.
Then
they made an application under section 151 and 52 for correction of degree. That was rejected. They preferred revision and application in this honorable court. That was allowed with a direction to convert that application 150 and 52 into section 114 read with order 47 rule 1. Review. And upon review, this and the modified judgment was passed once again. That is why two appeals were preferred.
Regarding the first
one is the appellate degree, against the appellate degree.
Then the appellate degree was wrong, showing a wrong, different premises.
Wrong.
So, but the next appeal which has been preferred is against the modified degree.
Modified degree.
So that is the one which you should look into. That is SA 59.
My lord. Second one is SA 41.
So nothing remains in SA 59 because that decree has itself been now modified. So this has become infructuous.
Modified to some extent, only the description of the property decree.
Whatever.
My lord.
Otherwise, these two, the second appeal would be barred by, the principle of stay.
Yes.
So you are challenging the same appeal then.
Same.
So SA 59 of 2023, let us narrate these facts and say that this has been rendered infructuous. And let us take up the other appeal then. SA 59 is the first appeal which you prefer.
First appeal.
SA 59 of 2023 ta prothome. The present second appeal has been preferred against a judgment of reversal. The title suit of the respondents for eviction of the appellants was dismissed by the trial court, which was reversed by the first appellate court in the title appeal. However, while doing so, the first appellate court erroneously mentioned different premises than the suit premises comma, which prompted the respondents to take out an application under sections 151 and 152 of the Code of Civil Procedure for rectification of the first appellate court's decree, full stop. The same being rejected, comma, a revision was preferred before this court, and a learned single judge remanded the matter by directing a conversion of the application under sections 151 and 152 into an application for review. Full stop. The review application was subsequently allowed, comma, thereby rectifying the first appellate court's decree, comma, this time reflecting the suit property to be the property as mentioned in the schedule of the plaint. Full stop. SA 59 of 2023 has been filed against the first appellate court's decree as it stood originally prior to review. Full stop. However, comma, due to subsequent modification of the said decree by way of review, comma, the present appeal has been rendered infructuous, comma, as a different second appeal has already been preferred by the appellants against the modified first appellate court's decree. Full stop. Accordingly, SA 59 of 2023 is disposed of as infructuous, full stop. Accordingly, comma, we take up SAT 41 of 2020 for hearing under Order 41 Rule 11 of the Code of Civil Procedure. SAT 41 we have taken up. What is the judgment of reversal? The suit was filed for, on what ground?
Mainly on the ground of original requirement. The learned trial court was pleased to dismiss the suit. With an observation, they failed to substantiate their so far the original requirement is concerned. So far the first appellate court is concerned, the learned lower appellate court was pleased to hold that so far residential portion of the concern, there is no further additional accommodation is required. The existing accommodation available to the appellant, plaintiff, is quite sufficient. But for the purpose of carrying on a business of the son of the plaintiff, further accommodation is required. And upon taking into consideration of that,
what is the suit property?
Suit property is soft room, only one single unit.
So, what is the ground of challenge to that?
The ground of challenge, my contention is twofold. First of all, when the first appellate court was of the view that so far the existing accommodation available to the plaintiff is quite sufficient, there is no need for
the existing accommodation is on the ground floor.
Entire building, it's a 4-storied building.
He also has something on the ground floor.
Yes, the suit property is one shop room in the ground floor, which is in my occupation.
No, residential portion cannot be a substitute for business purpose. If the residential accommodation available to the landlord is on the upper floors,
yes,
that would not be an
no, we are not there. But so far the ground floor shop room is concerned, which is the subject matter of the suit.
Yes.
Our contention is that in their nearby the ancestral house, there is enough accommodation.
Ancestral house is nobody's occupation. It's co-share. They are co-sharers.
After the death of their father, 2 brothers in occupation. And prior to purchase of the property, they used to reside there.
But all the co-sharers, both the co-sharers have equal rights over that.
No doubt, my lord. But so far that ancestral house is concerned,
you are speaking about the ancestral
house.
Your
lordship will find from the commissioner's report, 2 big rooms in the ground floor is there. If that be so, my humble submission be your lordship, that out of that 2 rooms, he is one of the co-sharer. He can very well use the 1 room of the ancestral property.
So what is the second ground?
The second ground, so far the partial degree is concerned. Your lordship kindly have a look. This partial degree has been passed in such a fashion. I am going to be evicted entirely.
Effectively, it's a full eviction.
Full eviction. Because I am not in.
Mr. Prout will continue tomorrow because for the partial degree, we have to look into the degree once. Due to paucity of time, the matter cannot be concluded today. Full stop. For further hearing under Order 41 Rule 11 of the Code of Civil Procedure, comma, let the matter be posted in the list tomorrow under the same heading. Please come back tomorrow. Tomorrow will conclude. SA 59. There was a can in connection with SA50, yes. ওই SA59 যেখানে বললাম dispose of as infractuous.
Can 1.
Full stop can 1 of 2020 within bracket old can 133 of 2020 bracket closed is also disposed of accordingly. এটা আগেরটা। এটা তো শুনছি। না 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 এটা তো এটা মেরিটেড ডিসপোজাল জাজমেন্ট 59টা ডিটাচ করে দিতে পারেন না 59টা এখন থাক যদি কোনো কাগজ অনেক সময় দেখা যায় যে এক সময় আছে লিস্টে শুধু 40 হ্যাঁ ওটা তো ডিসপোজ অফ হয়ে গেল ওটা ফাইলটা আজকেই নামাবেন না লিস্টে শুধু যেটা পেন্ডিং রইলো সেটা দেবেন